इसका रुपए नहीं। उनका बचपन था ना?
Supplementary list, item number 1.
My lord, I am in VC, my lord. My lord, it's a single bench matter, my lord. It relates to inaction of police. It's the assignment of honorable single judge, my lord. It should have been registered as CRL MP.
But you have filed it as WPCRL.
My lord, it has been wrongly, my lord, nomenclature.
All right, but for that you have to file an interim application for change of nomenclature.
My lord, within 2 days I will file.
All right. Learned counsel appearing for the petitioner submitted that in view of the prayer made in the writ petition, CRL MP is maintainable and he intends to file an interim application for conversion of WPCRL to CRL MP. List this matter immediately after filing of such interim application with the second copy of the brief. Yes. As per the report of the SR also. So it got a line article. As per the report of the SR also, CRL MP is maintainable. Hello? Yeah.
Obliged.
Item number 2.
Lordships. The minor girl has been kidnapped on 14/5/22, Lord. But is going to expire 1 year, Lord. But she has not yet been rescued. And this Lordship, your Lordship,
steps have been taken.
no, Lord, no, nothing, Lord. That is completely wrong information. I must say that. Lordship, see that. Lordship,
consistently, my lord, since the last 1 year,
let me complete.
Making
No,
allegations. But
let me complete.
What does the police have?
Yes, let me
any
complete.
invested interest not to do it?
Let me complete.
Please.
Let me complete.
Just
Yes.
a minute.
How many every date, Lord, they are giving the information. We are taking steps. Lord,
Just a minute. Since
yes, Lord.
this is
It's very unfortunate, Lord.
Please have your patience.
My Lord.
You have lodged an FIR.
Yes,
you
Lord.
means Rasmita Satpathy,
Yes.
how she is related to the victim?
My daughter, Lord.
Okay. She is the mother of the victim girl.
Yes,
and you mentioned in the FIR that the victim girl is aged about 14 years.
14 years.
Right?
Yes, ma'am.
And since 14/5/2022, in the night at about 2 o'clock, she was not traced out.
My Lord.
And you came to know from some persons that she was moving with one Manoj Guchayat, right?
Yes. Yes.
His house is at Rengali.
Yes.
PS is Rengali Dam site. Then another person is Amar Naik.
Yes.
And they are the, according to you, you came to know that they are the persons who are responsible for the missing of your victim girl, right?
Yes, and more importantly, petitioner, the opener 5, Manoj, is an accused, having 2 cases against him still pending.
So
yes,
this FIR seems to have been lodged on 14/5/2022.
My Lord.
And accordingly, case has been registered under section 363 against the named persons.
My Lord.
Okay.
My Lord.
So thereafter, what order has been passed by this court?
Yes,
time to time?
several dates they have taken that they will rescue, trying to rescue.
No.
Let me complete.
Please, have your patience.
Let me complete. Yes.
So
in each date, but and the my Lord.
No, fact remains that till date the victim girl has not been rescued.
And your Lordship already handed over the matter to the crime branch again.
Crime branch DSP is in charge of it, my lord.
Yes.
He was present in the court personally.
Yes.
My lord, all exhaustive steps have been taken. My lord, how can Mr. Patnaik say that
No,
we're not taking
how can you say what type of step?
See the latest status report, my lord.
This is a step.
My lord, they have
1 year.
What?
Wait.
My lord, when it is a case of elopement, my lord.
Elopement, that is very wrong.
My lord, no. How can you say that?
Elopement.
What is the date of birth of that girl? Please have your patience. What is this? Yes, date of birth.
You have the certificate you have filed, birth certificate, NHS
Yes.
4.
What is the
But,
date of birth?
yes, date of birth means that is 339 2008.
हाँ?
3/3/2004.
These are
Full लिखा है।
2008.
2003.
Full लिखा है जी।
3/3/2004.
जन्म date.
Date of issue में।
Date of birth. Date of birth. 3/3.
अच्छा 3/3/2004 okay 3/3/2004
4.
and date of occurrence
That
is
occurrence is
as per FIR
that is 4/5/2022.
4/5/2022. So that means she is 16.
No.
So hold on. अच्छा 18. So she has already become major now.
No, yes, now.
No, not at the time of even at the time of leaving the house. She has already attended the age of 18.
No, blood. That is 14 years, blood.
The date of birth, just see, date of birth is.
Yes.
Date of birth ଆପଣ 3/3/2004 ବୋଲି କିଛି dispute କରୁଛନ୍ତି କି?
Dispute sir.
ଆପଣଙ୍କ document.
ଆପଣଙ୍କ document. Please come to the that birth certificate annexure 4.
Yes.
Is it 3/3/2004 or something else is written?
I think 8.
8.
8 was.
କଣ ଏମିତିଆ document କଣ ଦେଇଛ? Why have you filed such type of document? Have you got the original one?
Original. But it is 14 years. But the
Huh?
Other.
Yes, 2003/2008.
आधार कोड लगाई।
Sorry, आधार लगाई। 2/2/2008. 3/3/2008.
3/3/2008.
Right.
So 2008 mean all right. It is 14 years and 2 months ago.
Yes.
Okay. So as on date also he is maybe 15 years to 3 months. Okay. Okay. So initially who was conducting the investigation?
That is the state police, blood. That is the IIC.
Huh? Mrs. Patnaik, who was initially
Since
IIC. That is the IIC Rengal Dam site.
Rengali dam site PS, and it has been handed over to
Rengali Dam Site PS. Okay.
Yes, madam.
Then since when, as per the order of the this court, the crime branch has taken over investigation?
My lord, 1/8/2022.
The order was passed on
1st of August 2022.
2022. Order was passed. Let us see what is that order. On 8/2022. Okay, this order reads like this, that Mr. Patnaik Land Council, appearing for the petitioner, has ordered this court to ask the crime branch, CBCID, to take over investigation in order production of the victim, even though we do not find the role of the police under so and so is blameworthy, but as a confidence building measure, we direct the state to transfer the case to CBCID. All right. So that was the direction on 1/8/2022, and when in fact the investigation was taken over by CBCID.
Since we first filed the
Yes.
since 1/8, we have filed the since 31 28, we had given a letter, my lord. By 10/8/2022, we had started receiving instructions Your Lordship may see this instruction, my lord. This
No, we are putting a pertinent question that there was a direction of this court
yes.
on 1/8/2022 to the crime branch to take over investigation of the case. Our query is that when, in fact, the crime branch took over the investigation.
My lord, first information that we received from the crime branch after investigation is on 28/2022. 20th of August. After one, it was handed over to the CBI.
Okay.
But this report
From the TSP.
today you are filing.
This is the latest one.
Okay.
But this is given by DSP, CAW, and
He is the one person. He is the person who is personally looking after it, my lord.
he's from the
Crime branch. From crime branch.
There is one unit has been there. That is investigation unit of crime against women and child.
Crime against women, CAW.
Unit has been formed. So that is now from 2020 it has been developed, and it is in all district areas.
So what today's instruction, please read it out what you have mentioned here.
These are also 15/4 instruction, my lord.
No, this
today's instruction, your lordship, you see, there are almost 18 points that you have given. Steps have been taken to locate the accused person and the victim in Paradip areas, but they could not be located. Steps have been taken to trace out the victim and accused in Orissa, Jharkhand border areas of Mayurbhanj district, and it was learned that they have moved towards Kolkata, Howrah to work as coolie labor. Searches have been conducted at different probable locations of Kolkata and Howrah areas, but they are not yet traced. Photographs of the accused person has been pasted in different locations of Kolkata and Howrah areas, including Babughat bus stand and Howrah railway station areas. Kolkata police has been requested to trace out the accused and victim if available in that areas. Financial investigation. Neither the accused nor the victim have any financial transaction done since this case. The Financial Intelligence Unit of Government of India provided information that no transaction done by both since this case. No new account is available in their names. Basing on the information of Financial Intelligence Unit regarding availability of one life insurance policy of Manoj Gochait in the Canara Bank, Canada HCFC Life Insurance Company, documents and persons concerned were verified and identified as another Manoj Gochait of Kendrapada district. 9. Polygraphy test of suspected persons, Amar Patra alias Prasant, has been done at FSL, but his involvement in this could not be proved. Neither the accused nor the victim are in contact with the respective family members. IMEI numbers of mobile phones of accused have been searched, but no information elicited. Neither the accused nor the victims are active in any known social media platforms. Searches have been conducted in Angul districts in the house of the accused and his relatives, but no incriminating material recovered. After receipt of some tip-offs, searches have been conducted in different locations of Keonjhar and Raulkal area. The search operation still continuing in both places in mines, industrial belt of both districts. Mobile service providing companies have been requested to provide SIM cards issued using the Aadhaar cards of the accused and victim. Their response is awaiting. With assistance of the cyber unit of the CIDCB, CDR of suspected numbers are being monitored. Suspected numbers are put on legal interception and the data are now under constant scrutiny. Request has been made to all mobile service providers to provide dump data of some strategic locations, and the received data are now under scrutiny. Hence, under the above circumstances, I humbly submit that I am taking all these efforts.
Come to number two. Steps have been taken.
Yes,
trace out the victim, and you have learned that they have moved to Calcutta and Howrah. Learned what is the source. Then you know their movement.
My lord, I'll just take your lordship to the different kind of.
Just see
that is that is.
Apply in what sort of form, how the witnesses are to be there, and how much time should pass once you apply to give objection to if any person wants to object, they can object, and thereafter a date will be fixed. Both of you will appear with your respective witnesses, sign then that register, and then the marriage certificate will be issued. What this notary will do?
Notary affidavit may let's say that declaration of marriage may let's say.
There are
In 1940,
we have issued so many directions that this notary are not authorized to do all these things. So in some cases, their attendance were also secured here, and we gave them that appropriate action will be taken. The state may withdraw that authorization given to them to act as notary public. Why they are indulging on all this type of acts? Who is this notary public? S.K. Mahanti.
Yes,
Which area is, man? Which district is?
The district is Balesur.
Balesur district.
Balesur district.
Okay.
This is a self-declaration attested by the notary,
authenticating
your marriage without authority.
That produce that let that person ensure the appearance of that person, notary. Who is to ensure the appearance? IACO?
In that case, my lordship, that my prayer may be before my lordship that the
we want to stop all these types of things.
The victim also the major
cases we find notary. The girl must not be knowing that what is required for a valid marriage, how the marriage is to be registered, and this thing will go on in the notary will do manage things, and thereafter there will be no value to that, and the girl's life would be spoiled. She will be thrown out. What he will do?
No, she's major.
Of doing it. After solemnization of marriage, you could have registered the.
I have also annexed in Annex 3 that the WhatsApp messages that has been forwarded by the victim also. Victim is also major and he is interested and he is legally admitted that he is legally wife
what
of the
we are doing, driving it out, that there must be some material before this court that there has been legal marriage between you, the petitioner, and that girl whom you say that her parents has detained him wrongfully.
Yes,
so unless you have a valid marriage with that lady, we cannot ask the parents of that girl to produce you and to hand over you. What authority you have got on unless you are the husband to have the custody of that girl?
So if you have really married, be man enough to go to your mother-in-law and father-in-law, bring your wife.
That
why
has been.
Why have you come to the court?
I have contacted my, but she is interested. She also forwarded the message some to make them to take away from his custody, Malaysia. For that reason, I have made the application, Malaysia. And the Annex 3, I have
sent this message, and from what mobile, who was using, in fact, that whether it was of the victim's message, your wife's message, so-called wife's letter, we will say, or it is somebody else has typed it, that once you go there, they will just catch hold of you. We do not know that may be the apprehension in your mind. That once I go to my wife's house, I may be arrested because a PS case has already been registered.
That has been registered, Malaysia. But my only that if instruction will come from the state Malaysia, then thereafter they'll.
Yes, Mrs. Patnaik.
On the last occasion, this honorable court didn't go into the merit of this case. Your lordship may take steps regarding this notary. But only the court wanted to know that just taken in for report that whether the girl is right.
Have you gone to this?
No, I have not. I have not taken because I've intimated this order. This order has been sent to the IAC and SP, my lord. We have not received any instruction. That is what I'm saying.
Somebody should go and ask this.
Yes, ask that. Only that much was needed. Whether the girl is fine, whether she actually is confined or not, or where she wants to come.
We are on a limited. We are interested to know, so far as the nature of this petition is concerned, whether that girl is staying with her parents on her own accord, or she has been wrongfully detained. She wants to go to her so-called husband or the petitioner, but she has been illegally detained since she has already attended 20. What is the age?
25.
So she has a right to go wherever
she has. Lordship may grant me a very short date. Maybe on Monday also I'll take.
All right. List this matter on 18th.
18th, yes, fine.
Okay, on 18th of September 2023. as requested by the Land Council for the state in order to obtain instruction as per order dated 26/6/2023. Just whether that IU investigating officer is a lady or is a
No, my lord.
otherwise you should ask somebody, a lady police officer.
Yes, she will.
So
Somebody will accompany.
Okay, right?
Lady officer.
Lady, the investigating officer, if she is not a female, should take one lady responsible police officer with him, and SP, like the SP Balasore, see that lady police officer go to interrogate the party, that opposite party. Which opposite party?
Opposite party number victim is the opposite number 6, and 7, 8 is the father and maternal uncle.
You want to see the victims is opposite party number 6.
6.
Opposite party number 6. Whether to ascertain whether there is any kind of wrongful confinement to her in the house of her parents, or she is voluntarily staying with her parents. Free copy of the order be handed over to the Land Council for the state. During course of argument, it is brought to our notice that a marriage declaration document has been typed out and in which the parties have signed, and it was shown before Mr. A.K. Mahanti, notary public, Baleswar, na? Baleswar. The inspector in charge of Baleswar Town Police Station shall ensure the attendance of the notary public on 18th September 2023 before this court, and the notary public shall apprise this court under what authority he has attested this marriage declaration. Declaration. Free copy of the order be handed over to the Land Council for the state. Acha, you want
21st.
All right, 21st. So that you will get some time.
Yes, some time and
21st. All right.
ତାଙ୍କର କଜ୍ ଲିଷ୍ଟ ସବୁ ଭୁଲ ଭାଲ ଆଡ୍ରେସ ଦେଇଛନ୍ତି ଟୁ ଫାଇଣ୍ଡ ଆଉଟ୍ ନା ସେ ଗୋଟେ ରୂପସାଟାକୁ ବାଲେଶ୍ୱର ସେଟା ଭୁଲ ଗଞ୍ଜାମ ଲେଖି ଦେଇଛନ୍ତି
ଏକେ ମହାନ୍ତି ନୋଟାରୀ ପବ୍ଲିକ ଆପଣ ପାଇଯିବେ କଲେକ୍ଟରେଟ ଅଫିସ
ସେଇଟା ପାଇଯିବେ ସେଇଟା ତ
ନୋଟରୀ ତ ପାଇଯିବେ
that I can get.
Yes, next case.
Item 4.
Or we have also filing a status report, my lord, and praying for some time, my lord.
ସେ ଯୋଉ ଦେଖିଦବ ଅନୁପାତରେ ମୋର ଡିସିସନ ଅଛି, division bench decision ବି ଅଛି ଯେ this notary public are not authorized to issue such type of certificate. ହେଲା
Petitioner's minor daughter was confined with opposite pen number 4 minus. Till date, we are unable to.
We have carried out some investigations, and CD is also there with me, my lord. But then, nevertheless, my lord,
the last order was passed on 31/7/23.
Yes.
So the order reads like this: that has produced a short status report regarding action taken by the police, but the police could not succeed to locate the victim girl. and for the said we provide further time. So after 31
today, my lord.
7
11/8 we are filing one.
What is the document you have filed to show that your daughter is a minor? No document is filed.
Only FIR has been filed.
No, what averment you have taken? It is 17 বর্ষ বেলি. So have you got any document with you?
Moment. I have only in paragraph 2. I have
Have you mentioned what is the date of birth of your daughter? This
Yes.
Gobind Sutar is the father.
Yes, my lord.
Where have you said that?
Where have you said that what is the date of birth of your daughter? And that she is a minor.
Para 2 re khali
Para
17 years
70
likhi.
years election.
Date of birth likhanti. You are father, then you are supposed to know the date of birth or
Yes.
some document, something of that sort.
We have found out that from the headmaster.
What
The
is
date
the
of
date?
birth is 28/2005.
Just a minute. 28
2005.
2005.
28.
What is the FIR date, Mrs. Patnaik?
It is 31/3/2023.
31/3/2023.
Remember.
Okay. So at present, she has become major.
Yes,
Yes,
right.
17 years, 7 months, 5 days.
So ବର୍ତ୍ତମାନ ଆପଣ ଯଦି ସେ ମେଜର ହେଇଗଲାଣି ତାର ଓପିନିଅନ ନେଇଗଲେ କାମ ସରିଯାଆନ୍ତା ତ
ଯାହା ଆମର ଲୋକାଲ ଇନଭେଷ୍ଟିଗେସନ ରୁ ଜଣା ପଡିଛି ଲୋକାଲ ଇନକ୍ୱାରି ଇଟ୍ସ a case of Philippine କାରଣ ତାଙ୍କ affair ଥିଲା but anyway but not minor ତ so we will definitely have to take steps to recover.
No, now she has become major.
Now she has become major. So khali we'll keeping all
you are not
efforts.
giving any information from your our daughter.
Till date we are not able to trace out her or get any information.
She is not keeping any contact with her friends, anybody, the family or the accused. Any phone tracking you have made, Mrs. Patnaik?
My lord, yes. IMS search a mobile phone. Four mobile phones we have given, my lords. But we have not received any instruction as per that. And it is also found out that the victim being annoyed upon the petitioner.
It's a case of elopement. If it is a case of elopement, once you apprise even the family members of the accused, so now she has become major.
That
so
yes,
would be no
yes,
problem.
no
So once they know it, they may, if they know at all that where the victim girl is there and where the accused is there, they can tell them so that they both of them
produce the girl.
Right. Once the statement is recorded before the magistrate, matter is over.
Matter is over. Yes,
because you have got the documentary proof. At least investigating agency is having documentary proof that now she has become major. Once she gives the statement and she says that no, I want to go with stay with the accused. Matter ends there.
That is the request we make to the IIC that you tell the family of that
right.
Let the girl come and say and go. There
would be no problem.
No problem.
Once you give that assurance, there would be no problem.
We do it in number. This time also I'll take care.
So we are keeping it to next month. You do it.
Yes, ma'am. Yes, ma'am.
All right. The Land Council Additional Government Advocate has produced the status report from the IAC Dhamnagar Police Station, which is dated 11/8/2023. She submitted that it's a case of elopement, and from the date of birth of the school admission register, it appears that now the victim has attended majority. Land Council seeks some further time to produce the up-to-date instruction and the result of the steps taken by the investigating agency to rescue the victim girl. As prayed for release this matter on the 16th October 2023.
Item number 5.
Yes.
I will read your lordship. The petitioner's minor daughter has been kidnapped, my lord, since 19th June 2020.
Minority. ना ଦେଇଛନ୍ତି FIR କିଏ ନେଇକିନି ଗଲା?
My lord.
Where is that FIR? Okay, annexure.
Annexure.
Oh, Devashish Singh.
Devashish Singh, my lord.
Same village or now on
No,
the
no, belongs to other village and other police station, my lord.
So this case was registered as it appears
My lord,
on
19/6/2023.
My lord. So what orders have passed previously?
And previously, the police was directed, my lord, including the
Okay, the last order seems to be passed on 2/9/2023.
My lord.
It is reported to us that despite serious efforts taken by police, the victim girl could not be tracked out. Okay, so once we directed the opposite party number 3 and to take all efforts to find out the victim girl, but the police could not achieve the success despite their efforts. We believe in the capability of the police to recover the victim girl, and hence we direct Superintendent of Police Nayagarh, opposite party number 3 in particular, to lead the operation for recovery of this one so by the next date. Yes, Mr. Das, what development has been made after that order was passed? That order was passed on 2/9/2023.
Well,
so 2/9/2023 means
this month.
Okay, few days back. It's just 14/9/2023. This report is also dated. Okay. So you have indicated that what steps you have taken.
Yes, we have taken.
IO examined the informant, other witnesses. Okay. Seized the original birth certificate. Ascertained that it is mentioned 1/7/2007. So the document filed by the learned counsel for the petitioner with the petition is correct. Okay. Then you examine this, that the accused in connivance with his parents also
kidnapping the minor girl, my lord, from the lawful guardianship under the inducement of the marriage and conceal her illegally with the assistance of these relatives. The IO, along with a special team formed for the above purpose, has also conducted raid in relatives' houses of the accused Devashish Singh in probable suspicious places. House of accused Gullu Champati of Khordha district, then Mala Kudi Dalavan Sai, Tarimi, Nirakarpur, Puri district and Nuapada, Chandanpur and nearby areas of, and also in Bhubaneswar Old Town, could not find the accused and the victim there. Then, my lord, we made a CIG, publication of the photographs in different places, my lord, probable places, my lord, and places of the test victim, namely so and so, my lord. And the commissioner of police also have been informed, my lord. And then we also collected the available mobile numbers and we were also trying to get the CDR analysis, my lord. Then we also checked the bank accounts of the, my lord, in paragraph 7, my lord. There is no transactions, my lord. So we need some more time, my lord, to get.
Have you got the case diary with you?
No, I have not received, my lord. Next date I will produce, my lord, case diary and all.
Because if you have,
yes, my lord.
IO has searched all these places.
Yes,
there must be search list to.
I'll produce, my lord.
Okay.
My lord.
Because how you are to conduct search at a particular place, that is mentioned in the CRPC.
Yes, I
so whether
yesterday I talked the IS.
Otherwise, it is very easy to mention in the case diary. We went there, saw.
I'll produce all the documents.
Right.
Yes, ma'am.
Madam, they have filed 2 cases before the Honorable Court. One ABLPL number 7841 of 2023 and one 482 CRPC, my lord.
that accused person, main accuser, has filed, my lord. CRL MC number 2874 of 2023. My lord.
What stand the accused has taken?
He prayed for quashing of FIR main accused.
On that ground, what is the ground?
Ground.
What she has stated about your daughter?
That
अरे appear करना दी ताधीरे
नहीं ताधीरे appear करनी
appear करना दी copy पाइबे आपण जानिबे आपनकर झियो सेतर हुए affidavit file करथिबो कोन देइथिबो. If you are interested, Mr. Please verify those two. What is the number?
But I have filed in my additional affidavit, my lord.
Today?
That I filed previously, my lord. Page 2, para 5, my lord.
माने stand जोना पड़ियो ना झियो stand ताधीरे.
That has been filed since 31st July 2023. Additional affidavit that is in the cause list. That is reflected in the cause list. Para 5, page 2.
अच्छा. APL number अच्छा you have given.
Yes, sir.
That is filed by Pratap Keshari Swanso, file an anticipatory and the main accused.
I'll get the petition.
Okay. See that what is the stand
Yes,
taken.
sir.
All right. All right. The London Council for the State has produced the status report dated 14/9/2023 from IIC Chandapur Police Station in the district of Nayagarh regarding the steps taken by the investigating officer to trace out the victim and to arrest the accused persons. The Land Council for the state submitted that he may be given some time to produce the case diary and to take instruction from the investigating officer as to whether there are corresponding documents to substantiate the stand taken in the status report about the steps taken to rescue the victim girl. The London Council for the petitioner has brought to our notice that an additional affidavit has been filed by the petitioner in which it is mentioned that in connection with the case registered at the instance of who is the informant in that case? This present petitioner. At the instance of the petitioner, Chandapur PS case number 107 dated 19/6/2023 was registered under section 363 of the Indian Penal Code against one Devasi Singh, and in connection with that FIR, the one Pratap Keshari alias Bulu Champati has filed an anticipatory bail application before this court by ABLAPL number 7841 of 2023. And the main accused, Devasi Singh, has filed an application under section 482 of CRPC, wide CRLMC number 2874 of 2023. The Land Council for the state submitted that he will also verify the records of those two cases to know the stand of the accused persons. As prayed for, list this matter in the week commencing from 16th October 2023. The Land Council for the state shall apprise this court about the latest development and also produce the status report and the case diary of say your case number so and so. Hala. Free copy of the order be handed over to the Land Council for the state for compliance. Yes.
Obliged.
16, my lord. 10.
Right, 1610 it will come.
Item number 6. My plea, Your Honor, that the victim girl has returned to home, and the police has also recorded her statement.
You want to not press?
Not press, my lord.
The London Council for the state has produced
Now at least nobody will say that
status
it doesn't do anything.
Status report from the IAC Jaleswar Police Station, wherein it is mentioned that the victim girl has been rescued on 3/8/2023, and after completion of all formalities, she has been handed over to the parents, and she is now staying with her parents, and the case has been closed as a mistake of fact by Jaleswar PS FR MF number 332 dated 21/8/2023. The status report produced, taken on record. Land counsel for the petitioner also submits that the victim girl has returned home and he doesn't want to press this writ petition. Accordingly, writ petition stands disposed of. Yes, next.
Obliged, my lord.
Item 7.
Mr. Shankar Prasad Pani and R.K. Panigrahi.
May I please, Lordship?
Rescued. Yes, Mr. Victim girl rescued. It is stated by the Land Council for the state.
My lord.
Right? Okay. Lekon. The Land Council for the state has produced the written instruction received from OIC, Baliapar Police Station, dated 11/9/2023, wherein it is mentioned that during course of investigation, the victim girl has been rescued from Visakhapatnam, Andhra Pradesh on 7/9/2023, and after completion of all formalities, she has been handed over to her mother on 9/9/2023, and the accused Govinda Jana has been arrested and forwarded to court of London JMFC Basta on 10/9/2023. The written report is taken on record. The 164 CRPC statement has also been produced to Pellakidyandu, along with the written report, which are taken on record. The Land Council for the petitioner also submits that she has received instruction that the victim girl has returned to her, and she doesn't want to press this application, accordingly disposed of. So, yes, next.
Bless me.
Item number 8.
Your Lordship, item 8, I seek a short adjournment, Your Lordship.
The 2005
Your
criminal
Lordship,
appeal,
yes, Your Lordship, on the
and
last.
paper books have been prepared.
Yes,
So 18 years have passed. So your client is on bail or what?
yes, Your Lordship, the client was on bail, Your Lordship, but
Then we'll cancel the,
Your Lordship, on
we'll
the
recall
last.
the bail order.
Your-
If you are not arguing the case of criminal appeal of 2005 and enjoying freedom because of delayed disposal of the appeal, then we'll recall that bail order, let the accused remain in custody, and whenever you will get prepared, we'll take up the criminal appeal for hearing.
Your Lordship, on the last occasion, instruction had been called for about the whereabouts, Your Lordship. We
But
also,
whose whereabouts?
the whereabouts of the accused, Your Lordship. Still, then, till now, the appellant, we are not able to establish any contact with the appellant.
You know better. That's a different matter. We are whether you are ready, and he has been granted bail by this court, right?
Yes, Your Lordship.
So you are representing him. Once you argue the matter, whether he is available or not, that's a different matter. If the result of the appeal so desires, then he will be again taken into custody. If he is acquitted, then matter ends there. So no, there is no necessity that at the time of appeal hearing, the appellant should remain present here and stand here. So you are to get yourself ready to argue the criminal appeal, and if you are not prepared, then other orders will follow.
You are engaged by legal aid or
No, it's
Your
a regular
Lordship.
appeal.
regular appeal?
It's a regular appeal.
Criminal
Your
appeal.
Lordship.
30302 case.
Yes, Your Lordship.
So have you got the paper book with you?
Yes, Your Lordship. We've got the paper book.
So
Yes.
what time you require?
Your Lordship, I only next week, any date, Your Lordship. we
Okay,
fix it.
get ready and
Yes, Your
argue the matter. You will argue, or the senior Mr. Naik will argue,
Lordship.
or you have not decided who is to argue the matter?
You should argue.
You argue the matter.
I'll do, Your Lordship.
Okay. What is the good name?
Lordship, Binny Mishra.
Huh?
Binny Mishra, Your Lordship.
Vinny Mishra. Land Council submits that the matter may be taken up next week. She has received the paper book and she will argue this matter. Place this matter in the week commencing from 18th September 2020. Weekly रे पूरे दबो जो उत्तर हबो कोनी गुड़ाको हियरिंग गुड़ाको तमे आनो नियादे जदि भी गोटे मिड्स रे पड़ी जाईची ताको वीकली लिस्ट रे आनो सब तो हियरिंग गुड़ाको वीकली लिस्ट अछि आ गुड़ाको पांचटा छटा हियरिंग केमती सप्लीमेंटरी आउछ तार it's all right there was an order but henceforth you add all those hearing matters to the weekly list गोटा सीरियली आसीबो निया जिवो गोटे पर गोटे हला कोडा कहार हो ऐसे थामो सी तो आर्गुमेंट करिए तो yes
Your place, Your Lordship.
Item 9.
May I please, Your Lordship? I'm on virtual mode, madam. I'm on virtual mode. Item number 9. Madam, here, Your Lordship, the appellant is convicted under section 302, sentenced to undergo RI for life. My Lord, may kindly see the judgment Your Lordship will prima facie satisfy that is a prima facie not a case of 302. Only if I will place the fact of the prosecution case in.
just a minute paper book आएंगे paper book बाहर करो Mr. Tripathi
Yes, my lord.
you have got the paper book
Yes,
with you?
yes.
Okay 302 and sentence is life imprisonment
My Lord.
okay before we go to that you come to the charge page 24 place it
That you on or about the 4th day of April 2002 at 9:30 p.m. at the Chanagiri under Jankia PS did commit murder by intentionally causing the death of Ointu Naik, grandfather of informant Babuli Naik, and thereby committed an offence punishable under section 302 IPC and within my cognizance.
so the appellant name is Subhas Naik.
Madam.
Date of occurrence is 4/4/2002. Time is 9:30 p.m.
Yes, Your Lord.
And place of occurrence is
Channagiri.
Channagiri. Okay, Channagiri. Under Jankia police station.
Madam.
Okay.
The deceased is
then the name of the deceased is Ointu Naik. Ointu Naik is the grandfather of the informant. Grandfather of informant, and the name of the informant is
Babuli Naik, PW3.
Babuli Naik is PW?
3, madam.
PW3. Okay. Now you please come to the FIR. Let us see.
FIR is page 20. The contents are page 20.
Right. Read it.
ମୁଁ ଶ୍ରୀ ବାବୁଲି ନାୟକ ପିତା ବୟସ 27 ଦୈତାରୀ ଖଣ୍ଡଗିରି ଥାନା ଖୋର୍ଦ୍ଧା ଅଦ୍ୟ ତା 4/4/2002 ରାତ୍ର 12:15 ସମୟରେ ଥାନାରେ ଉପସ୍ଥିତ ହୋଇ ଲିଖିତ ଅଭିଯୋଗ ଆଗତ କରୁଛି କି ଆଜି ରାତ୍ର 9:30 ସମୟରେ ଆମ ଗ୍ରାମର ସୁବାସ ନାୟକ ପିତା ମଙ୍ଗଳା ଠାକୁରାଣୀଙ୍କ ପାଖ ରାସ୍ତାରେ କାକୁ ମହାନ୍ତିଙ୍କ ସହିତ କଳିଗୋଳ କରିଥିଲା। ମୁଁ ସେଇ ସମୟରେ ମଙ୍ଗଳାପୀଠ ଆଡ଼କୁ ଯାଉଥିଲି। ସୁବାସକୁ କଳି ନ କରିବା ପାଇଁ କହି ତାକୁ ତାଙ୍କ ଘରକୁ ଭିଡ଼ି ଆଣିଲି। ସେ ପୁଣି ଘରୁ ବାହାରି ଗଣ୍ଡଗୋଳ କରିବାକୁ ଆସିବାରୁ ମୁଁ ଆମ ସାହିର ଅଶୋକ ରମେଶ ପ୍ରଭାକର ମାନେ ତାକୁ ଅଟକାଇବାକୁ ଚେଷ୍ଟା କଲୁ। ସେ ମତେ ଅସଭ୍ୟ ଭାଷା
କାହା ସାଙ୍ଗରେ କଳି କରୁଥିଲା କଣ କାକୁ ମହାନ୍ତି କିଏ ଆଉ ଗୋଟେ ଲୋକ
another person madam.
Okay, not the deceased.
No madam.
All right. So ତାପରେ ସେଇ ସମୟରେ ମୁଁ ଯାଉଥିଲି ସୁବାସ କୁ କଳି ନ କରିବାକୁ କହି ସୁବାସ ମାନେ appellant.
ସୁବାସ is the appellant.
Right. ତାକୁ ପୁଣି ଘର ପାଖକୁ ଭିଡ଼ି ଆଣିଲି କିନ୍ତୁ ସେ ପୁଣି ଯାଇକି ଗଣ୍ଡଗୋଳ କଲା ଆସିବାରୁ ମୁଁ ଆମ ସାହିର ସୁଆଣ୍ଡଙ୍କ ସହିତ ଚେଷ୍ଟା କରି ସେ ମତେ ଅସଭ୍ୟ ଭାଷାରେ ଗାଳି ଦେଲା। Yes, continue. Then
ଗାଁରେ କୌଣସି ବାହାଘର ହେଲେ ମତେ ସାଙ୍ଗରେ ନେଉନା ଏହା କହି ମତେ ମୁଥା ମାରିଲା। ଲୋକମାନେ ଛଡାଇଲେ। ମୁଁ ଗ୍ରାମରକ୍ଷୀ ପାଖକୁ ଗଲି। ଗ୍ରାମରକ୍ଷୀକୁ ସାଙ୍ଗରେ ଧରି ଆସିଲା ବେଳକୁ ମୋର ଜେଜେ ଅଇଁଠି ନାୟକ ଗଣ୍ଡଗୋଳ ଖବର ପାଇ ଘଟଣାସ୍ଥଳକୁ ଯାଇ କାହିଁକି ମୋ ନାତି ସହିତ ଗଣ୍ଡଗୋଳ କଲୁ ବୋଲି ସୁବାସ ନାୟକକୁ ପଚାରିଲେ
ମାଡ଼ଗୋଳ କଲୁ
ମାଡ଼ଗୋଳ କଲୁ ବୋଲି ସୁବାସକୁ ପଚାରିଲେ। ସୁବାସ ମୋ ଜେଜେଙ୍କ ଛାତି ଓ କନମୁଣ୍ଡକୁ ଭୁଷା ମାରିଲେ। ଜେଜେ ମାଡ଼ ଖାଇ ତଳେ ପଡ଼ିଗଲେ। ଏହା ଜାଣି ତାଙ୍କ ସ୍ତ୍ରୀ ଓ ପୁତୁରା ବୋହୂ 3 ଜଣ ମିଶି ତାକୁ ଘରକୁ ଟେକି ଆଣିଲେ। ବୁଢ଼ା ସେତେବେଳେ କହୁଥାନ୍ତି, ସୁବାସ ମୋ ଛାତି ଓ କନମୁଣ୍ଡକୁ ବିଧା ମୁଥ ମାରିଲା। ମୋର ମୁଣ୍ଡ ବୁଲଉଛି, ଅନ୍ଧାର ଦେଖାଯାଉଛି, ମତେ ଡାକ୍ତରଖାନା ନିଅ। ସେତେବେଳେ ଆମ ଗ୍ରାମରେ ଅଟୋ ରିକ୍ସା ମିଳିଲା ନାହିଁ। ଜଙ୍କିଆ ବଜାରରୁ ଆସିଥିବା ଗୋଟେ ଅଟୋକୁ ମୁଁ ଗାଁ ପିଲାମାନେ ଯୋଗାଡ଼ କରି ଘର ଆଡ଼କୁ ଆଣିଲା ବେଳକୁ ବୁଢ଼ା ମରିଯାଇଥିଲା।
So it's only fist blows has been given.
My lord.
Age କେତେ ଥିଲା ବୁଢ଼ାର ଡିସିଜ୍ ର?
What is the PM report, Mr. Who is the doctor who conducted PM?
PW13, my lord. PW13, and his evidence is at page 55 of the paper book.
Please come to that. Let us see. Then we'll.
From the very beginning, I'm placing from the.
Yes.
Madam. On 5th April 2002, I was attached to District Headquarters Hospital, Khorda, as Assistant Surgeon. On that day, on the instruction of SDM Khorda, I conducted postmortem over the dead body of Ointha Naik, son of late Sakhi Naik of village Chanagiri, Adisai, PS Jankia, District Khorda, and found as follows: abrasion of size 3 inch in 2 inch over the middle of the chest, 2 inch of size 3 inch to 2 inch on the left cheek below the ear. On dissection, I found small tear on the external ear. I found small hematoma in the left cheek. The injuries were antemortem in nature, and the cause of death may be due to trauma at the left ear, stimulating vagus nerve causing heart attack. A blow at the left ear can cause death, death, since vagus nerve connects the heart as well as the ear. Time since death is 12 to 24 hours. This is the PM report, such answer. In the cross-examination, Your Lordship, I did not find any internal injury excepting one small hematoma in the left cheek. Trauma also includes emotional shock. Emotional shock can be caused due to irritation, excitement, and frightening. Stimulation of vagus nerves cannot be identified during internal examination. It is a fact that I guessed that there was a stimulation of vagus nerve. It is not a fact that my opinion was not correct. My observation is superficial.
Okay. The eyewitnesses have supported the prosecution case.
My lord, the eyewitnesses have stated like the person of the.
Who are the eyewitnesses to the occurrence?
Eyewitness to the occurrence, my lord.
PW2, my lord.
PW2, yes.
All right, let us come to that evidence.
Yes, 31. I know the informant Babuli Naik and this is Ointu Naik. The alleged occurrence took out 1 year back at about 9:30 p.m. I saw Subhas Naik quarreling with the Kalu Mahanti. Babuli Naik was going. He took Subhas to his house by dragging him. Ashok and Ramesh also dragged Subhas Naik and left him in his village. Thereafter, Subhas Naik again came from his house. Ointu Naik came and inquired from Subhas Naik near Trinath temple as to why he was abusing in obscene words. Subhas dealt fist blows to the chest and root of the ear of Ointu Naik, due to which Ointu Naik fell
on the ground.
Hearing hula raised by me, my mother and elder mother and aunt and other persons arrived at the spot, and they lifted Ointu inside his house. Ointu Naik told them that due to assault by Subhas Naik, he was unable to see and suffering from head ringing. Ointu Naik told us to take him to hospital. But since there was no auto rickshaw in our village, we went to Jamkia to bring an auto rickshaw to shift him to hospital. By the time we arranged the auto rickshaw and reached the village, we found Anshu Naik was dead.
It's a case where fist blows were given.
Yes.
One on the perhaps chest and the other seems to be on the which ear, that is left ear, right? So as a result of which what has been caused internally, that there has been small hematoma on the left cheek,
Yes.
and injuries has been opined to be antemortem, cause of death due to trauma at the left ear stimulating vagus nerve causing heart attack. Okay.
Right.
So a blow at this one so can cause the death. So any citations you have got, Mr. Mahapatro?
Citations have not ready with me now.
Fist blows on the ear causing death. It would not be 302. Or what would be the other offenses? Whether it's a 323 or 325?
It will be 323.
No, because the injuries is grievous in nature. Because it has caused hematoma. We cannot say that it's a simple one. 323 says, and no weapon has been used. That's why we are excluding 324 or 326, right?
Right.
So it would be either 323. It cannot be hot is defined there. And if hot has been defined in 319, it's just a bodily pain, disease or infirmity. But so far as grievous hot is concerned, in order to bring the matter under 325, grievous hot, it defines first is emasculation, permanent privation of the sight of either eye, permanent of the privation of the right ear, that is not there, then privation of any member of the joint, that is not there, destruction or permanent impairing of the powers of the joint, that is not there, permanent disfiguration of the head or face, that is not there, fracture or dislocation of the bone, eta to nahi bode, fracture by jagi jajegi, that is not there. Any hurt which endangers life or which causes sufferer to be during space of 20 days, it's unable to follow his order. That was dangerous to life. Has he stated anything in that?
No.
But he stated that it's a and caused death due to trauma. So it is dangerous. Why you say no?
Well, you'll also be the cross-examination also, the doctor has given the reply.
Trauma also include emotional shock. Emotional shock can be caused due to irritation, excitement, frightening. Stimulation of so and so cannot be identified due to during internal examination. It's a fact that I guess that there was so and so.
In the cross-examination.
ये केप से बाहर फिर बताओ डॉक्टर. साइटेशन खाता डॉक्टर होगी तो मनुपत्र भर मनु सर्च टाइप करो फिस्ट ब्लो FIST blows ছাড়িয়ে তারপরে ER EAR डेथ ହେଲା
ଧୀରେ ଏଇଥିପାଇଁ ମୁଁ ଭାବୁଛି
not ଲେଖ not P02 302 टाइप करो P02 ଟିକେ ଛାଡିକି IPC I.P.C C करो আইটাকে আগে ক্যাপিটাল করো। কোনটা দেখা যায়নি? ও সেটি দেখা যায়নি। डॉट पी डॉट सी ହେଲା ତାପରେ ଟିକେ ଛାଡିକି ମାର ଡଟ୍ କର ଡଟ୍ ଦିଅ ସି ପରେ ଡଟ୍ ଦିଅ ସେଇଟା ଲଗା ତା ଦେହରେ ଡଟ୍ ଟା ଟିକେ ତାପରେ ଲେଖ 323 ଗୋଟେ ଲେଖ 323 ତାପରେ ଟିକେ ଛାଡି ଦିଅ 325 ଲେଖ ସେ ଇୟର ଟାକୁ ଆଉ ଟିକେ କ୍ଲୋଜ କର ଯୋଉ ବ୍ଲୋଜ ଆଉ ଇୟର ଭିତରେ ଗ୍ୟାପ୍ ବେଶୀ ହେଇଗଲା ଆଉ ଟିକେ ଫିଷ୍ଟ ବ୍ଲୋଜ ପରେ ଯୋଉ ହଁ ଲଗେଇ ଦିଅ ହଁ ବାସ୍ ଏଣ୍ଟର ମାର ଛାଡି ଦିଅ এটা ছোট করে ইয়ে করি কন্ট্রোল করি ଟିକେ ছোট করো ହଁ ବାସ୍ ଥାଉ ସେଠି Cookies blows on his face. By dealing to food on his face, alleging that he had joined the rival, so on so. ডিপ্রেশন ও ফ্র্যাকচার যেটা লাঠি মারাইছে তারপরে উঠুনি কোন তিরিশন না না ଏପଟରେ ଟିକେ ଉମେଶ ସାରଙ୍କ ପାଖକୁ ସେ ଦେଖ ଏଇ ନାଇଁ ଏଇଟାକୁ ଦେଇଦିଅ ଏଇ ପୋଜିସନ ମୁଁ ତା ଭିତରେ ଖାତାଟା ଦେଖିଦିଏ କିଏ ମତେ ଖାତା ଦିଏ ଯେ ଚାରିଟା ମୁଣ୍ଡରେ ବସିବି ନା ଆଉ ଗୋଟେ ଦିଅ ସେଇଟା ଏଇଟା ଦିଏ
Mr. Mahapatra, we are doing your job.
No.
It's not actually
You are supposed to do you are supposed to do all these things.
I'm also doing all my things.
No, nothing. Don't not doing nothing. The trial court acquitted the accused also in terms of the judgment. State preferred. Okay, then it was the High Court convicted under 304 Part 2. Acha. Three criminals appeal files and there was the income. Postmortem report was examined closely, and there are external paragraph 8, one on the temporal region, the another on the left knee. Third abrasions. Doctor has opined that the second injury could be result of the fall and that it is more likely that a person would simultaneously aim the head and also the knees of the victim while giving fist blows. Respondent number possibly delivered more than one fist blows with only one of them landed on the head of the deceased and other missed the target. This court did not agree with the observation of the High Court. Death was caused by subdural hemorrhage, not cardiac arrest. There was stated to be uncertainty regarding the cause of death. No weapon of possession. Okay. Lapses of him expanding the review application, etc. In our view, Acha, that is para 24. We have given our thought into the matter. In our view, some material aspects which are required to be taken note appear to have been somehow missed at the stage of sentencing, such as physical fitness of the respondent number 1, as he was international cricketer, was tall and well built and aware of the force of the blow that even his hand could carry. The blow was not inflicted on a person identically physically placed, but a 65-year person, more than the double of his age. Respondent number 1 cannot say that he did not know that the effect of the blow or plead ignorance on this earth. It is not as if someone has to remind him the extent of blow injury which could be caused by a blow inflicted by him. In the given circumstances, tempers may have been lost, but then consequence of the loss of temper must be borne. In fact, this court to some extent had been indulgent in ultimately holding the respondent number 1 guilty of an offense of simple hurt 323 IPC. The question is whether even the sentence mere passage of time, a fine of rupees 1,000 being an adequate sentence one. So the hand can be used as a weapon by itself, where say a boxer, a wrestler, a cricketer, or an extremely physically fit person inflicts this pain. This can be understood where the blow may be given either by a physically fit person or more to a aged person. Insofar as the injury caused is concerned, this court has accepted the plea of a single blow by hand being on the head of the deceased. In our book, it is significant, which is an error apparent on the meetings also. Then kete esa sentence kete asila. The 323 roila. Tapre our sentence kete asila. Jelle ultimately sakko. Page number, para number.
1 year.
Ko page ko paragraph hai. Acha, we are not setting for much about how the irregular could be one under section 323. We do believe that indulgence is not required to be shown to the stage of sentence by imposing a sentence of 5 and letting the respondent to go without any imposition of sentence. That two views are possible that the review transaction is in the result allowed in addition to the fine imposed. We consider it appropriate to impose the sentence of imprisonment for 1 year. Reverse imprisonment. See, 87. The next question, what would be appropriate punishments on you tell me some it I just not earlier खाली 1000 टाका फाइन कर दिलो हाँ stimulate the punishment of it of next 1 year fine which may certain case, I think that is the fact that the incident is 30 years old and there is no past enmity between the accused one and no weapon was background. All right. So, all right. That is what the case is, Mr.
Yes.
All right.
Here the as per the evidences available on record, the deceased was 65 years old, and the quarrel was going on with one Kabu Mahanti. The PW3 intervened, and there was also quarrel between a little bit quarrel with the PW3 with the present appellant, and the PW3 dragged the appellant into his house.
Right.
But this appellant came again to quarrel with that Kabu Mahanti again, and at that time the deceased, who is the grandfather of PW3, he intervened and wanted to inquire why the present appellant was.
You want to say that there was no intention?
Yes,
That's right.
There was no intention, no weapon has been used, and the doctor said.
Okay, we understood.
All right, take down. Yes, Mr.
Yes,
323. 323, 1 year left. The petitioner, the appellant, Subhas Naik, faced trial in the Court of Additional Session Judge Kurda in ST case number 26/229 of 2002 for offense punishable under section 302 of the Indian Penal Code on the accusation that on 4/4/2002 at 9:30 p.m. at Channagiri under Jankia police station, he committed murder of one Ointu Naik, bracket hereafter the deceased, the grandfather of informant Babuli Naik is PW
3.
The London Trial Court had judgment and order dated 27/9/2005 has been pleased to hold the appellant guilty under section 302 IPC and sentenced him to undergo imprisonment for life. The prosecution case, as per the first information report lodged by PW3 Babuli Naik before the inspector in charge of Jankia police station on 5/4/2002 is that on 4/4/2002 at about 9:30 p.m. the appellant was quarreling with one Kakku Mahanti. And at that time, PW3 was proceeding towards
Kalu Mahanti.
Kalu?
Kalu Mahanti.
Acha, Kalu Mahanti like that. At that time, the informant was proceeding towards the temple the temple of Mangala, Mta capital Kardo. And he forbade the appellant not to quarrel and dragged him towards his house. However, when the appellant again proceeded towards the spot to create disturbance with Kalu Mahanti, the informant along with others, tried to restrain the appellant. But the appellant in turn abused them in filthy language. And complained before them that they are not taking him to attend the marriage feast in the village. And saying so, he dealt a fist blow to the informant. The persons present there tried to separate the appellant from the informant, whereafter the informant proceeded to call Gramarakshi and came back to the spot with Gramarakshi. At that point of time, the grandfather of the informant, that is the deceased, on receipt of message that disturbance was going on, came to the spot and confronted the appellant as to why he was quarreling with his grandson, that is the informant, bracketed PW3. Stop. It is further stated in the first information report that all on a sudden the appellant dealt fist blows on the chest and ear of the deceased, on receipt of which he fell down on the ground. The wife and other family members of the deceased removed the deceased to the house from the spot. And at that point of time, the deceased was telling that the appellant dealt fist blows on his chest and ear, for which there was head drilling. And he was noticing as if there was darkness everywhere. And he told his family members to shift him to the hospital. There was no auto rickshaw available in the village, for which when auto rickshaw was brought from the Jankia Bazaar, and then the deceased was removed to the hospital. Brought to the, but by that time the deceased was already dead. On such IOK are there? On such written report being presented before the IIC no OIC कर दो OIC of Jankia police station, comma Jankia PS case number Jankia PS case number 43 dated 5/4/2002 was registered under section 341, 294, 323, 302 of the Indian Penal Code against the appellant and PW 15 जो OIC लिखे ना ब्रैकेट लिख दो था नाटा भी लिख दी तो सेठी तना होची उमेश चंद्र गौडनायक ब्रैकेट PW 15 during course of investigation the IO bracket PW 15 examined the informant, visited the spot, prepared the spot map bracket exhibit 4, comma examined other witnesses, held inquest over the dead body and prepared the inquest report exhibit 1 and sent the dead body for postmortem examination, which was escorted by the constables and the relatives of the deceased. The appellant was arrested on 5/4/2002 and he was forwarded to court. The wearing apparels of the deceased were seized as per seizure list exhibit 6. The IO received the postmortem report marked as exhibit 3 and Dr. PW, PM Dr. Mr. Tripathi, PW
13.
and PW 13, Dr. Kailash Chandra Pradhan, attached to District Headquarters Hospital, Khurda, conducted the postmortem examination over the dead body and opined that the two injuries noticed on the person of the deceased were antemortem in nature and cause of death might be due to trauma at the left ear, stimulating vagus nerve causing heart attack. The IO sent the exhibits for chemical analysis and on 29/7/2002, he submitted charge sheet against the appellant under section 302 of the Indian Penal Code. On 3 it is the evidence.
31.
All right, 31/7/2000. In order to prove its case, the prosecution examined 15 witnesses. Then prosecution also exhibited such and such documents, details indicate. The accused statement page number. The defense plea of the appellant
Page 25
is one of denial. Any witness has been examined. किसी साक्षी एग्जामिन करछन कि जजमेंट
No.
Okay. No witness has been examined on behalf of the defense. All right. The London Trial Court, after assessing the oral as well as documentary evidence on record, has been pleased to hold that on account of blow on the left ear, it caused heart attack, resulting in the death of the deceased, and therefore the case, it's a homicidal case. The London Trial Court analyzed the evidence of the witnesses, that is PW2, PW3. So you ear question, the root of the ear myla, okay. PW4, 5, comma 10, and came to hold that the death of the deceased was due to the act of the accused. And it was further held that because of the age factor of the deceased, in all probability, the appellant must have the knowledge that such blow on the vital part like left ear in ordinary course of nature would have caused the death of the deceased. And he had assaulted the deceased without any provocation. And the deceased was 65 years old, and due to his assault, the deceased died few minutes after on the same night, and therefore found the appellant guilty under section 302 of the Indian Penal Code. Mr. Deepti Ranjan Mahapatra, Land Counsel appearing for the appellant, contended that though the evidence of the eyewitnesses are consistent, that the appellant gave 2 fist blows to the deceased, one on the chest and the other on the root of the ear, for which the deceased fell down on the ground, but there is absence of any material to show that there was any premeditation on the part of the appellant to commit such crime. And it appears that getting some message about the disturbance, the deceased came to the spot, and tried to interfere and
inquire as to why the appellant was abusing the PW.
and interfere and ask the appellant as to why he was abusing in obscene language. The Land Council submitted that due to such quarrel on being provoked without using any weapons, if 2 blows have been given to the deceased under no stretch of imagination, it can be said that the act of the appellant would come within the definition of murder. And it may be a case of 323 of the Indian Penal Code, as the doctor who conducted post-mortem examination has noticed one abrasion on the chest and one bruise on the left cheek. And he specifically stated that he did not find any internal injury except one small hematoma in the left cheek. And though the doctor stated that injuries were antemortem in nature and cause of death might be due to trauma at the left ear, stimulating vagus nerve, causing heart attack, and a blow at the left ear can cause such death, since vagus nerve connects the heart as well as the ear. But in the cross-examination, he has stated that trauma also includes emotional shock, and emotional shock can be caused due to irritation, excitement, and frightening. And stimulation of vagus nerve could not be identified during internal examination. And he guessed that there was stimulation of vagus nerve. The Land Council submits that since the nature of injuries caused to the victim, to the deceased, would not come within the definition of grievous hurt as defined under section 320 of the Indian Penal Code, it may at best be a case under section 323 of the Indian Penal Code. The Lenin, Mr. Tripathi, Priyavata Tripathi, Lenin Additional Standing Counsel, on the other hand, supported the impugned judgment and submitted that number of witnesses have stated as to how the occurrence took place and about the specific overt act committed by the appellant in assaulting the deceased. The Land Council submitted that it cannot be lost sight of the fact that the deceased was an old man.
65.
65 years old. And the part of the body on which the blow was given cannot be said to be a non-vital part. And the petitioner, the appellant being young, giving the fist blows on the vital part of the body, which resulted in causing hematoma and damage of and stimulation of vagus nerve, and ultimately resulting in the heart attack as opined by the doctor, and the fact that immediately after the occurrence the deceased died. The Lenin trial court was justified in convicting the appellant under section 302 of the Indian Penal Code, and therefore the appeal should be dismissed. Stop. After analyzing the evidence of the eyewitness we find that PW's 2 के eyewitness कहले 2 3 PW's 2 PW 3
4,
5.
4 and 5 okay are the eyewitnesses to the occurrence. PW2 has stated PW2 ro na de debe has stated that the appellant Subhas Naik was quarreling with one Kalu Mahanti. And at that point of time, PW3 was passing by that road, and PW3 took the appellant to his house by dragging him. Along with Ashok and Ramesh. Ashok bracket lekhi diyo PW5 and Ramesh hochi PW4. And left him at his house. But again, the appellant came from his house, and at that point of time, the deceased came to the spot and inquired from the appellant near Trinath temple as to why he was abusing in obscene language. Stop. At this, the appellant dealt fist blows on the chest and the root of ear of the deceased, due to which the deceased fell down. Hearing Hulla, the family members of the deceased and others arrived at the spot, and they lifted the deceased inside his house. And the deceased told them that due to assault by the appellant, he was unable to see and suffering from head reeling. And he told to take him to the hospital. PW2 further stated that there was no auto rickshaw available in the village, for which they went to Jonkia to bring one auto rickshaw to shift the deceased to the hospital. But by the time they arranged the auto rickshaw and reached at the village, they found the deceased died. Deceased is dead. Okay, deceased was dead. We have gone through the cross-examination. Nothing material has been brought out in it to disbelieve the evidence of PW2. PW3 PW3 so has also stated about fist blows given by the appellant. Not only to him, but also but also he stated about the dying declaration made by the deceased that due to the assault of the appellant on his chest and head, root of the ear, his head was reeling and he was unable to see due to loss of vision. In the cross-examination, he has stated that the appellant was complaining as to why they were not inviting him to the community feast, and why they were inviting him to the band party. The appellant was not remaining inside the house and repeatedly coming out of his house and started quarreling with them, for which PW3 went and informed the Gramarakhi. Nothing further has been elicited in the cross-examination to disbelieve the evidence of PW3. PW4 Ramesh Nayak did not support the prosecution case for which he was declared hostile. PW5 Ashok Nayak has stated that there was hot exchange of words between the appellant and PW3, and he along with other person took the appellant to his house and left him there. And they went to see Yatra, and when they returned, they found the deceased was in a serious condition. Thus, his evidence is silent as to how the assault took place on the deceased. No other witness has stated about the assault on the deceased. Thus, on analysis of the aforesaid 4 witnesses, it appears that PW2 and PW3 are material witnesses, but the assault on the deceased has been stated to by PW2, and dying declaration part has been stated by both PW2 as well as PW3. The doctor who conducted postmortem examination noticed the following external injuries. Quote କରିଦେବେ, and ତାପରେ ଯାହା ଲେଖା ହେଇଛି on dissection ସେଟା ଲେଖିବେ. He found one small tear on the external, the small hematoma in the left cheek. You find the injuries to be antemortem in nature, and the cause of death might be due to trauma and at the left ear, stimulating vagus nerve causing heart attack. The doctor stated that the blow at the left ear can cause such death since vagus nerve connects the heart as well as the ear. He proved the postmortem report marked as Exhibit 2. However, in the cross-examination, he stated that he did not find any internal injury except the small hematoma in the left cheek, and further stated that trauma includes emotional shock, and emotional shock can be caused due to irritation, excitement, and frightening stimulation of vagus nerve never can be identified during internal examination. He further stated that he guessed that there was stimulation of vagus nerve. In the background of the case, it appears that there was no previous enmity between the appellant and the deceased. There was no premeditation. The occurrence occurred on a sudden. When the deceased came to the spot and intervened and questioned the appellant, as to why he was abusing in obscene language. It further appears that no weapon was used for assaulting the deceased, and only fist blows were given on the chest and the root of ear of the deceased. In the case of Jaswinder Singh versus Navjot Singh, Jaswinder Singh versus Navjot Singh and others, reported in 2022, bracket rakhi diyantu, 7 Supreme Court cases, 6 to 8, where the factual scenario was that the informant Jaswinder Singh and one Avtar Singh, bracket PW3 and PW4 respectively, were traveling with the deceased Gurnam Singh in a Maruti car driven by the deceased. A dispute arose on the right of way between the accused and the deceased and the respondent number 1, bracket the first accused, and the deceased, and the respondent number 1, that is Navjot Singh, that is not like respondent number 1, Navjot Singh Sidhu, came out of the vehicle, pulled out the deceased from his vehicle and inflicted fist blows. Though the informant made endeavor to intervene, but the second accused, bracket respondent number 2, got out of the vehicle and gave fist blows to the informant. The car keys of the deceased were removed by the accused persons and they fled away from the scene of occurrence. And PW3 and PW4 took the deceased in a rickshaw to the hospital, where doctors announced the deceased to be dead. The postmortem report indicated two external injury, one on the temporal region and another on the left knee of the deceased, and both were abrasions. And the doctors opined that the second injury could be the result of a fall, and the cause of death has been opined to be due to cardiac failure. And on opening the skull, subdural hemorrhage was found present over the left parietal region and brain. And it was the hemorrhage which caused the death of the deceased. না এটিকে এটি খেলে এটা এটা না এটা ইয়ে করে দিয়েছেন। The Honorable Supreme Court was considering the review application in as much as the while deciding the appeal, the earlier bench found the respondent number one Navjot Singh এটা আচ্ছা okay second review petition है the respondent number one Navjot Singh Sidhu guilty under section 323 of the Indian Penal Code for causing voluntary to the deceased Gurnam Singh. However, a fine of rupees 10,000 was imposed on him since the incident was 30 years old and there was no enmity between the parties and no weapon was used. Stop. The Honorable Supreme Court in the aforesaid judgment of Jaswinder Singh further held that some material aspects which were required to be taken note of appear to have been somehow missed out at the stage of sentencing, such as physical fitness of the respondent number 1, as he was an international cricketer, who was tall and well built and aware of the force of a blow that even his hand would carry, and the blow was not inflicted on a person identically physically placed, but a 65 years old person, more than double his age. It was further held that the respondent number 1 could not say that he did not know the effect of the blow or plead ignorance on this aspect. It is not as if someone has to remind him of the extent of injury which could be caused by a blow inflicted by him. It was further held that in the given circumstances, tempers may have been lost, but then the consequence of the loss of temper must be borne. And though the court upheld the conviction of the respondent number 1 under section 323 of the Indian Penal Code, but taking into account that the hand can also be a weapon by itself, where, say, a boxer, a wrestler, or a cricketer, or an extremely physically fit person inflicts the same, and where a blow is given either by a physically fit person to a more aged person, on the head, it was held that no indulgence can be shown at the stage of sentence by only imposing sentence of fine and letting the respondent number 1 go without any imposition of sentence. Accordingly, the Honorable Court, in addition to the fine imposed, thought it appropriate to impose a sentence of imprisonment for a period of 1 year, rigorous imprisonment. Imprisonment for a period of 1 year. Rigorous imprisonment for a period of 1 year. Stop. Considering the factual scenario of this case, as we have already found that there was no previous enmity between the appellant and the deceased, there was no premeditation to commit the crime, the deceased was not initially present at the spot when the quarrel started, but he came subsequently and tried to interfere by asking the deceased why he was abusing in obscene words, which in all probability caused provocation in the mind of the appellant, who dealt fist blows on the chest and root of the ear. Since no weapon of offense has been used and the injury caused to the deceased, as per the post-mortem report finding of the doctor bracketary PW13, doesn't come under any of the 8 clauses of such section, we are of the view that the conviction, the act of the appellant would come within the definition of causing voluntarily hurt, punishable under section 323 of the Indian Penal Code. Accordingly, the conviction of the appellant under section 302 of the Indian Penal Code is hereby set aside. And he is convicted under section 323 of the Indian Penal Code and sentenced to RI for 1 year and to pay fine of rupees and to pay fine of rupees 1,000 in default to undergo SI for 1 month. It appears that the appellant was taken into judicial custody on 5/4/2002 and he was granted bail on 11/10/2002 and he was released on 28/10/2002 while during trial and after the impugned judgment, he was taken into custody on 27/9/2005 and he was granted bail by this court on by order dated 12/5/2006. केते हला calculation को लेके प्रथमटा केते इतला कहले गला के तोड़ प्रथम 5/4/2002 केबे बाहरला 28/10/2002 सो ये हला 6 मास 6 months आउ 5 रेले 23 दिन ओके देन तापर केते हला जजमेंट डेट केते 27/9/2005 12/5/2006 तामाने ये हला 5 मास ये हला 3 मास प्राय पाखा नहीं दी मास के तो 5 मास माने हां ताले पाखा पाखी 7 मास खंड होची 7 मास होनी बजे 6 months हेले हे जाउची so 12 मास हे जाउची आशा it appears that the appellant has already undergone not only the substantive sentence imposed by us today, but also the default sentence. Therefore, he shall not be taken into custody further in connection with the case. Accordingly, the criminal appeal is partly allowed. But Mr. Mahapatra,
My lord.
Henceforth, we should not exercise, will not do your job. We'll look out the decision and you will be held by the state council. What is this? You are to search for the
I'm extremely
citation.
sorry. I'm
Lot
extremely
of time
sorry.
could have been saved.
Right?
Lot of time could have been saved.
But
We wasted about half an hour, 45 minutes for that searching.
I'm sorry for that.
Weekly list. This is a list for on Monday and Tuesday, I think you are mentioning, not today's list. Mention if any item you want to mention on today's list, okay?
But I may pardon to mention, my lord, item 80, my lord, and that is, I have filed IA interim application on the ground of illness of the mother, my lord.
80.
80. IA has not come. I pray the next Thursday.
What is the IA number?
1991 of 23. 1991 of 23.
20?
3, my lord.
Have you given a copy to
Yes,
the
ma'am.
state?
Yes, ma'am.
On what ground you are seeking for it?
On the ground of illness of the mother.
Okay, take down. Item number 80 of hearing list.
80.
Mr.
I have filed power, but power has not been filed.
Mr. Jugal Kishore Pandal and Council submit that he has filed power for the appellant. Along with IA number 1191 of 2023 for interim bail of the appellant on the ground of his mother's illness. And copy of the interim application has been served on the Land and Council for the state. So
I also undertake to serve another copy.
The Land Council for the state seeks some time. Seeks some time to obtain instruction on the same. Please this matter. Order Please this matter in the week commencing from 25th of September 2023 along with IA number 1191 of 2023. Yes.
Fresh conviction matter. And another two tied up matter.
I may pardon 1991. 1991. 1991.
1991.
Attend lordship that bailable number 674 by 2022 last week list thila but there 40 674 by 2022 weekly list thila but last week that's a connected but 5692 already dispose of this
final time delisted
देखिए हम जल्दी असाइनमेंट क्यों नहीं करते
leftover matter now.
Item number
26.
The criminal appeal against conviction. So you remain there when time permits. I can take up. Wait.
Pardon, item 93 lordships, one BA case lordship. So kindly take a many convenient date lordships. 2 years sentence to 2 years.
Just a minute.
93.
Item number
93 lordships.
93 कौन अपन चाहते हैं?
Any date no permanent lordship can take up my lord. Because 2 years sentence for 2 years and.
এলাজে এটা 2021 মସିହାର vigilance appeal এটা. So
all the pensioner
has been prepared.
Only patients lordship, that's why any date lordship permanent my lord.
We'll see that it cannot be taken up. Criminal appeal, it will take time. And old appeals are there. It's a 2021 appeal. How can be taken up? We'll see. Yes, Mr. Panda.
Lords, I have to mention 3 criminal revisions which were in your lordship's list. Against order of discharge. They were in the list. And they have not been taken up for about 6 months almost. Yes. Now, there was an interim order that on petitioners moving for adjournment, it will be liberally construed.
Okay.
Now, because of this fact that it has now exceeded 6 months, the Special Judge Vigilance Balangir is reluctant to grant it.
No, criminal division has been assigned to me.
Lord, that are vigilance matters. The PC Act, এটা PC Act ତ
କଣ ହେଇଛି ଟିକେ ବୁଝିଦିଅ ନମ୍ବର ଗୁଡା ଦିଅନ୍ତୁ ଯଦି ଆମ ଆସାଇନମେଣ୍ଟ ହବ ନେକ୍ସଟ ୱିକ୍ ରେ ନିଏ
Another prayer by Lord, one criminal appeal 82 of 2020, item number 75 Lord. I pray for interim bail.
just a minute judge. 75
my Lord. Corrective matter, criminal appeal
75 ରେ ଏଟା ଚାରଟା ଖଣ୍ଡେ appeal ଅଛି
last item my Lord, criminal appeal 82 of 2020 Lord.
82
of 2020.
ହଁ କଣ ହେଲା ଆଜି
interim bail, I filed interim bail my mother.
what is the number of that IE?
Yes my Lord, 2231 my Lord.
2231
Yes my Lord.
of 2023
Yes my Lord.
who ground ରେ file କରିଛନ୍ତି
mother seal yes my Lord.
Mr. Das ସେ ନମ୍ବର ଟା ଟିପନ୍ତୁ ଦେଖି ଦିଅ ଆଉ ଗୋଟେ କପି ଦେଇ ଦିଅନ୍ତୁ ଏକ୍ସଟ୍ରା ଦେଖନ୍ତୁ CRL number 82 ଏଟା item number 75 Mr. Chittaranjan Sahu Land Council appearing for the appellant submits that an interim application has been filed by IA number 2231 of 2023 for interim bail of the appellant on the ground of mother's ailment, and a copy of the same has been served on the Land Council for the state. Stop. Land Council for the state seeks some time to obtain instruction on the interim application. List this matter in the week commencing from 25th of September 2023 along with the connected criminal appeals. Yes, it is order tab karibe CRL number 82 of 2020 रे हैला. Yes,
item number 40 वाला
40
and vigilance appeal
ठीक
of the year 2010.
ठीक है हाँ कौन है
Vigilance appeal of the year 2010. No substantial sentence, only fine. And in lieu of fine, my lord, some
default sentence is
default sentence is there. Yes, already my lord going to return.
कौन माने vigilance case?
Again, vigilance case. It can be disposed of on many occasions. It was there, and I have also made a mention before my lord. It was
okay. So vigilance council remains to present. Where is that? Is not there. Please ask vigilance council. If he comes and Sanjay Das को नाम लिखा है जी, now they contact करूँ तो coming week रे कौन तो present रहिबे, है ना? थोड़े आरंभ हो गया, अब कुछ असुविधा नहीं है. 83 हाँ कौन हला? There are 4 matters, 4 criminal appeals. 36 of 2014. हाँ.
Order dated this started 2023 manner. Please to direct the government to take instruction. I have already 11 years 8 months in custody.
Just a minute. Let us बाहर कर दो. Let 36. R.B. Mishra Land Council for the appellant submit that while imposing substantive sentence of 11 years, Land Trial Court has not taken into account the provision under section so and so. Imposing a punishment higher than one to the submitted remain in custody for 11 years and so on. Default sentence is reduced on आनिले की रिपोर्ट आनिले केते कोन हेजन देखिले ताऊ ये अदर टोटल से सेम ट्रायल रे माने for all the 4 appellants were found guilty
11 years month 9 days
कहार
ए
माने जो कमल फ्रैंकलिन पात्र
मैल
तार रिपोर्ट डेट टा केते कोन
रिपोर्ट डेट वाला अछि 6/2/9
हां
6/9
6/9/23
मैल
सेटा केते देखुची 11 years
2 months 9 days
2 months 9 days
total 4084 days
हां ठीक अछि अन्य गुडा आछि की
नहीं गुटे मगाइतला
अच्छा
No my lord. Kindly see the last person operating person last line.
नहीं मिस्टर
just a minute
दास केवल तार मगाइनी अन्य मानकर भी मगाइतला ଯେ ଆପଣ ଅନ୍ୟମାନଙ୍କ ପାଇଁ ତ ନାହାନ୍ତି,
Yes, madam. And for other.
ସମସ୍ତଙ୍କ ପାଇଁ ଅଛନ୍ତି। ଆଉ ବାକି ରହିଲେ ନରସିଂହ ନାୟକ, ରମେଶ ଗୌଡ଼, ଭରତଚନ୍ଦ୍ର ପ୍ରଧାନ ଆଉ ସନାତନ ରୟ।
Sanatan Rai, that is 11 years, 2 months, 9 days, madam.
ସେଟା ରିପୋର୍ଟ ଡେଟେଡ୍ ସେଇ 6 9
Aye, no.
ରିପୋର୍ଟ ଡେଟେଡ୍ 6/9/2023 11 years କେତେ କହୁଛନ୍ତି?
11 years, 9 months, 2 months, 9 days.
ହଁ ସେ ଏକା ସାଙ୍ଗରେ ତ ଗଲେ ଆଉ ଧରା ପଡିଥିଲେ।
ଆଉ ଗୋଟେ ହେଲା my lord, that is
ନା କୁହନ୍ତୁ।
ଭରତ ଚନ୍ଦ୍ର ପ୍ରଧାନ।
ରିପୋର୍ଟ ଡେଟ୍ ସେମ୍।
Report the same, my lord.
6/9/2023
ଭରତ ଚନ୍ଦ୍ର ପ୍ରଧାନ, my lord, 9 years,
9 years
9 months, 2 days.
9 months 2 days ତ ଇଏ ତ ବାହାରି ପାରିବନି। ତାପରେ ଆରଟା ଆଉ ଗୋଟେ ରହିଲା ନା ଆଉ ଦିଟା ରହିଲା, ନରସିଂହ ନାୟକ ଆଉ ରମେଶ ଗୌଡ଼।
ଧୀରେନ କିଲାର, my lord.
ଧୀରେନ
କିଲାର।
ସେ କିଏ?
Now after number 2, madam.
କୋଉଥିରେ?
36 2000.
ଓ 36 ଟା 2 ଜଣ କି?
3 ଜଣ madam.
କୁହନ୍ତୁ। ହଁ ଧୀରେନ ଖିଲା କୁହନ୍ତୁ।
11 years, 7
ଆଚ୍ଛା ତାମାନେ ଏଇଟା ଯୋଉଟା କହିଲେ ଏଇଟା ହଉଛି A1 ର କହିଲେ। ହଁ ତାପରେ A2 ଟା ହଉଛି ଧୀରେନ ଖିଲାର କେତେ?
11 years, 7 months,
11 years 7 months
14 days.
14 days ସେଇ ଗୋଟେ ରିପୋର୍ଟରେ ଆସିଛି ତ?
ଆଜ୍ଞା।
ଆଉ ଗୋଟେ ରହିଗଲା ତା ଦେହରେ ଗୌରୀ ଶଙ୍କର ପ୍ରଧାନ ସେଇ ଆପିଲଟାରେ।
ମାନେ ଯୋଉ କିଲର କହିଲେ ମାନେ କିଲର ର କମଲ କିଲା ପାତ୍ର, ଫାକଲିନ ପାତ୍ର, my lord. That is, my lord, 9 years, 9 months, 5 days.
ଆଉ 11 years କହୁଥିଲେ?
ସେଟା ଫାଷ୍ଟ ଟା କହିଲେ।
11 year madam, Dhiren Kilo.
Dhiren.
And number 2, madam.
1 ଟା ଠିକ ସେ କୁହନ୍ତୁ ଶୁଣନ୍ତୁ।
ଏଇଟା ହେଲା ମାନେ କମଲ ପାତ୍ର ଯୋଉଟା,
ହଁ
ଫ୍ରାଙ୍କଲିନ ପାତ୍ର, ସେଇଟା ହେଲା ମାନେ 9 years, 9 months, 5 days.
ଓକେ।
ଗୌରୀ ଶଙ୍କର ପ୍ରଧାନ, madam.
ଗୌରୀ ହେଲା A3।
Gowri, my lord, 9 years, 6 months, 3 days.
ବାକି ଆଉ ଦିଟା କ୍ରିମିନାଲ ଅପିଲ ରହିଲା, ସେଗୁଡା କଣ ସିଙ୍ଗଲ ଆପିଲାଣ୍ଟ?
ପୂର୍ଣ୍ଣଚନ୍ଦ୍ର ପାଣିଗ୍ରାହୀ
ସେ କୋଉଥିରେ ଅଛି?
Criminal appeal 150/14. Appellant number 2.
ଆଚ୍ଛା
9 years,
just a minute 150 ଟା ବାହାର କର। wait just ତା ଦେହରେ ବି 2-3 ଜଣ ଅଛନ୍ତି। ହଁ ଭରତ ଚନ୍ଦ୍ର ପ୍ରଧାନ ଗଲା, ତାପରେ A1 ପୂର୍ଣ୍ଣଚନ୍ଦ୍ର ହେଲା A2। ହଁ
9 years, 11 months, 5 days.
ଆଉ ଗୋଟେ ରହିଲା ସୁରେନ୍ଦ୍ର ନାୟକ। ଏଟା କୋଉଥିରେ ନେଇକି ଯାଉଥିଲେ, କୋଉଥିରେ କ୍ୟାରି କରୁଥିଲେ ଗଞ୍ଜା? ବୋଲେରୋ। ଆଚ୍ଛା ଦିଟା ବୋଲେରୋ ନେଇକି ଯାଉଥିଲେ। ହଉ ହଁ A3 ଟା କେତେ? ସୁରେନ୍ଦ୍ର ନାୟକ।
ସୁରେନ୍ଦ୍ର ନାୟକ, my lord, 9 years, 9 months, 4 days.
9 years 9 months 4 days। ଓକେ। ବାକି ନରସିଂହ ନାୟକ,
ରମେଶ ଗୌଡ଼,
ରମେଶ ଗୌଡ଼। ଆଚ୍ଛା ବାହାର କର 120 ଟା ବାହାର କର। ସିଙ୍ଗଲ ଆପିଲାଣ୍ଟ। ହଁ କୁହନ୍ତୁ।
ରମେଶ ଗୌଡ଼, my lord,
ରିପୋର୍ଟ ଡେଟ୍ ସେଇ ଅଛି।
ରମେଶ ଗୌଡ଼, my lord, 9 years, 10 months,
9 years 10 months
22 days.
22 days. Yes, next. ଆଉ ଗୋଟେ ରହିଲା ନରସିଂହ ନାୟକ, ଏଇଟା ଦେଖ 14ଟା ବାହାର କର, 14/2014
Correctional like manner of owner of the
ଯାହା ବି ହଉ ସେଇ ସେଣ୍ଟେନ୍ସ ସମାନ ହେଇଛି ତ
সেটা owner মানে
ଗାଡି
গাড়ি
কনফিউজ ও আচ্ছা 454 ସେ ଛାଡ ওকে সো সেটা নট নেসেসারি আচ্ছা now we come to the operative portion of the judgment. total face আচ্ছা ट्रायल के जन फेस करथिले 8 जन 8 persons face trial. Okay, offense वाला 20B2C 20B2C तापरे जजमेंट ऑपरेटिव पार्ट रे आसिले आमे देखुछु जे समस्तंकु अच्छा एवरी all the 8 found guilty and sentence is padiva sentence taking into account the deleterious effect of such kind of drug abuse shattering the fabric of the society economic of the nation and also looking at the age of the convicts in the absence of any material prior involvement so and so it's 11 years a NDPS act diyo 11 years and fine hella 1 lakh default sentence la RI for 1 year. To be कहला factors to be taken into account for imposing higher than the minimum punishment. Achha. Where the minimum terms of imprisonment or amount of fine is prescribed for any offense committed under this act, the court may, in addition to such factors, as it thinks, take into account the following factors for imposing punishment higher than the minimum: use of threat and use of violence or arms by the offender at a 9. Fact that the offender holds a public office at a 9. Fact that the minors affected by the offense 9. Fact that the offense is committed in an educational institution, social service facility, or in the immediate vicinity of such institution or faculty, or in other places in which schools, children, and students resort to at a 9. Fact that the offender belong to organized international or any other criminal group, at 39. Fact that the offender is involved in other illegal activities facilitated by commission of offense. अच्छा आउ किछि आसिला कि तांको ना रे किछि ये बाकी से 20B2C रो punishment ता minimum थाला 10 years रहला (20B2C) right involves commonly with the rigorous imprisonment shall not be less than 10 years, but which may extend to 20 years, and shall also be liable not less than 1 lakh. Okay. तो एटा को जदि 10 को नहीं आसीबा आउ फाइन अमाउंट तो 1 लाख रहिबो ता डिफॉल्ट सेंटेंस टा को टे कमेई दवा ताले सब केते जण ऑलरेडी बाहर जिवे आ बाकी थोड़ा को रिसेंटली बाहर जिवे होला देखो ए सब गुडा को ए जो सेकंड टा को छाड़ देकिन बाकी सब गुडा कनेक्टेड कर दियो माने क्रिमिनल अपील 36 2014 120 ऑफ 2014 देन 150 ऑफ 2014 then 296 of 2014 है लिखियो the appellants in criminal appeal number 36 of 2014 namely 36 टा बार करो namely Kamal Franklin Patro alias Raja, Dhiren Khila and Gauri Shankar Pradhan, appellant 14 टा बाहर करो. Appellant Narasingh Naik in CRLA number 14 of 2014. 20 टा बाहर करो. Appellant Ramesh Gowda in CRLA number 120 of 2014. 150 टा बाहर करो. Appellants Bharat Chandra Pradhan, Purna Chandra Panigrahi alias Kumar and Surendra Naik in CRLA number 150 of 2014. तापरे 296 टा बाहर. And appellant Sanatan Roy in CRLA number 296 of 2014. Judgment to press. Case trial in the court of London Session Judge Special Judge Ganjam, Barampur in GR case number 04 of 2010 bracket N/TR number 13 of 2010 for commission of offence under section 20B2C of the NDPS Act. Charge kodagala. LCR bar karo. Charge kahin dega bar karo. On the accusation that on 21st September 2010 at about 3:45 p.m. near Bhatti Kalwa Temple of Bolonthara, in two four-wheeler vehicles, that is Bolero bearing registration number OR 02BA 2123 and Mahindra Xylo bearing registration number OR 10G 6726 were found in possession of 316 kg and 150 grams of contraband ganja contained in 33 different packets in contravention of the provision of section 8C of the Narcotic Drugs and Psychotropic Substance Act 85, bracketary hereafter NDPS Act. The London Trial Court, by impugned judgment and order dated 27/11/2013, found all the appellants guilty. Operative part paso judgment. Found all the appellants guilty under section 20B2C of the NDPS Act and sentenced each of them to undergo RI for 11 years and to pay fine of ₹1 lakh, in default to undergo further RI for a period of 1 year. Stop. The prosecution case in short is that paragraph 2 in order to prove its case the London Trial Court after defense plea paragraph exactly manage the London Trial Court, after considering the oral as well as documentary evidence available on record, came to hold that one thing, some of the co-accused persons are released on interim bail. Upon custody certificate produce but interim bail can take instance from that. कोटा कहले ना ना आपण जो कस्टडी सर्टिफिकेट आनी चंदी सेही बेसिस रे एति डेज जो कहउछन सेटा परफेक्ट तो हां सेटा तापर से मान कैलकुलेशन करी छाड़ीबे कोन मु एटा को 10 इयर्स कर देबी बाकी डिफॉल्ट सेंटेंस टा को रिड्यूस कर देबी हला डिफॉल्ट सेंटेंस टा 1 ईयर अछि मु ताको 2 मास कर दउची ହେଲା ତେଣୁ 10 ବର୍ଷ 2 ମାସ ହେଲେ ଯୋଉମାନଙ୍କର ହେଇଯିବଣି ତାଙ୍କୁ ଛାଡିଦେବେ ଆଉ କଣ ଏହା ତ କଥା ଆଉ
ପୁରା ଏଣ୍ଟ୍ରି ପିରିୟଡ ଥିଲେ
ହୁଁ।
ମଝି ପିରିୟଡ ଯୋଉ ଏଣ୍ଟ୍ରି ପିରିୟଡ ଯାଇଛନ୍ତି ଆମ କୋର୍ଟରୁ ଲାଷ୍ଟ
ହୁଁ।
ଯେ ରେକର୍ଡରେ କହୁଛି ଯେ ଏଣ୍ଟ୍ରି ପିରିୟଡ ଯାଇଛନ୍ତି ତାପରେ ସରେଣ୍ଡର କରୁଛନ୍ତି ନା ନାହିଁ କି ସରେଣ୍ଡର ଦେ ନଟ୍ ଫାଇଲ୍
ସବୁ ସେ ମୁଁ ସେ କ୍ଲାରିଫାଇ କରିଦେବି ଲାଷ୍ଟ ପୋର୍ସନ ଯିଏ ଯାଇ ନଥିବ ସେ ବାକି ଯୋଉ ପିରିୟଡ ସେ ଆସିବ ଯିବ
ସରେଣ୍ଡର ଯଦି ଆସନ ନେଇକି ରହିଥିବେ
ହଁ ସେ ତାର ବୁଝିବେ फाइंडिंग गुड़ाक इम्पोर्टेंट फाइंडिंग गुड़ाक देखिदो से पारा एंड रे सब रही तापरे लास्ट टू लिखि दियो द लैंड इट वाज held that further held that the submission of the Learned Counsel for the defense that there is non-compliance of Section 50 of the NDPS Act is totally misconceived, as it is a case of search of the vehicle and not the personal search. And provision under Section 50 of the Act, under the circumstances, is not required to be mandatorily complied with in view of the language of such provision. तापर एमती सब पैराग्राफ रे जो फाइंडिंग दिया है अल्टीमेटली सेटा कोट कर दो हला दी लर्निंग काउंसिल आपण सब अपील ले ये करछंती ओके योर गुड नेम इज हां मिस्टर राजीव बिहारी मिश्रा लर्निंग काउंसिल appearing for all the appellants in the 4 criminal appeals though doesn't dispute that on the basis of the materials available on record, the conviction of the appellants under Section 20B2C of the NDPS Act is quite justified, but contended that the punishment imposed by the Learned Trial Court is not in accordance with law. He further submitted that Section 32B of the NDPS Act has not been taken into account while imposing higher than the minimum punishment prescribed under Section 20B2C of the NDPS Act. The Learned Counsel further submits that some of the appellants have already undergone more than 11 years of substantive sentence and others have undergone more than 9 years of sentence. And in such a scenario, if minimum sentence as prescribed under 20B2C is imposed and the default sentence for non-payment of fine is reduced, the appellant some of the appellants will be released on bail, and some of the rest of them will have to face undergo imprisonment for some lesser period. as per the order dated, you last order ta pass ହେଇଥିଲା ମୁଁ ଦେଖୁଥିଲି ଯୋଉଟା 36 କଣ, as per the order dated 31/8/2023 passed in CRLA number 36 of 2014, the Land and Council for the state was asked to obtain custody certificate of all the appellants. And today, the Land Council for the state has produced the same, from which it appears that appellant number 1, Kamal Franklin Patro alias Raja, has, as per the custody certificate dated 6/9/2020, had undergone 9 years, 9 months and 5 days, comma. Appellant number 2, Dhiren Khila, has undergone 11 years, 7 months, 14 days. And appellant number 3, Gauri Shankar Pradhan, has undergone substantive sentence of 9 years, 6 months and 3 days. Similarly, appellant Ramesh Gowda in CRLA number 120 of 2014, as per the custody certificate dated 6/9/2020, has undergone 9 years, 10 months and 22 days. CRLA. And appellant number 1, Bharat Chandra Pradhan in CRLA number 150 of 2014, as per custody certificate dated 6/9/2023, has undergone 9 years, 9 months and 2 days, comma. Appellant number 2, Purnachandra Panigrahi alias Kumar in CRL number 150 of 2014, has undergone 9 years, 11 months, 5 days. And appellant number 3, Surendra Nayak in CRL number 150 of 2014, has undergone 9 years, 9 months and 4 days. And similarly, I would work 296 criminal appeal. And appellant Sanatan Roy in CRLA number 296 of 2014, as per the custody certificate dated 6/9/2023, has undergone 11 years, 2 months and 9 days of sentence. Section 32B of the NDPS Act reads as follows. More decision achi dekhikin lekhi deba, hala. On a bare perusal of the operative part of the judgment, where hearing on the question of sentence has been described, it is apparent that the London Trial Court, while imposing 11 years of sentence, substantive sentence, has not taken into account the provision under Section 32B of the NDPS Act. Therefore, while upholding the conviction of the appellant under Section 20B(2)(c) of the NDPS Act, I reduce the sentence from 11 years to 10 years. So far as the fine amount of rupees 1 lakh is concerned, since it is the minimum sentence provided for the offense, while upholding the same, comma, the default sentence, that is RI for a period of 1 year, is reduced to RI for 2 months. It is stated that some of the appellants, that is K bail interim bail जे बेल बर्तमान अच्छी कहूँ माने बाहर अच्छा okay, it is stated that the appellant in Sanatan Roy in CRLA number 296 of 2014 is on interim bail.
Regular bail.
Acha, is on regular bail. Then
appellant number 2 in criminal appeal 36/2014 is in custody.
तो मु कौन आपन कहूची बेल ले की कहजो जे हमर कस्टडी आसिया कहूना is on bail. The since I have reduced the sentence to 10 years and default the substantive sentence to 10 years and the default sentence to 2 months, if the appellant, whichever the appellant has already undergone such period, is to be released forthwith from judicial custody if their detention is not required in any other case. Stop. The appellant Sanatan Roy, if he has already undergone the period of sentence which has been imposed by me today, is not required to surrender in court, and if it is found by the consent, the Lennon trial court, that as per the report submitted, custody certificate submitted by the jail superintendent authority, he has to further undergo the sentence, then he will be taken into custody to undergo the remaining part of the sentence. With the modification in the sentence, CRL number 36 of 2014, 14 of 2014, 150 of 2014, and 296 of 2014 are disposed of. No, disposed of, dismissed kar do, with modification of sentence. Yes.
Item 87.
No, criminal appeal, that will be listed separately. That is for release of vehicle. 14 of my kichi order pass kariyo. So that is separate appeal. 454 appeal. Mr. Das, you do one thing, you just file those custody certificate so that it will be taken on record. Okay. Yes, next.
Item 87, madam.
Yes.
Out of 10 years custody, is in 9 years, some odd days, madam. Maybe it could take a hearing or.
এটা কোন মানে 20B2C?
আজ্ঞା 20B2C
আর রিডিউস তো করিও বনছে তো মিনিমাম দিয়াইছি মানে ইউ ওয়ান্ট হিয়ারিং হিয়ারিং তো ଅଛି ଆଉ ଲିଷ୍ଟ ରେ ଆଉ କଣ କରା
ବେଲ୍ ବି ଗୋଟେ ପକେଇଛି ବେଲ୍ ପିଟିସନ ଆସିବ ନେକ୍ସଟ ୱିକ୍ ଆସିବ ବେଲ୍ ପିଟିସନ ସହିତ
ବେଲ୍ ନମ୍ବର କେତେ କୁହନ୍ତୁ
ଟୁଡେ ଆଇ ଫାଇଲ୍ଡ ଆଇ ଏମ୍ ସପ୍ଲାଇଂ ଟୁ ମାଇ କୋର୍ଟ ମାଷ୍ଟର ମାଇ ଲର୍ଡ
ଓକେ ଏ ଯୋଉ ମିଷ୍ଟର ମାନସ ଚନ୍ଦ ଲ୍ୟାଣ୍ଡ କାଉନ୍ସିଲ appearing for the appellant submits that he has filed an interim application today for grant of bail to the petitioner, to the appellant. And the appellant has already undergone
appellants. 4-5%. 9 years, some odd days, my lord.
9 years have already undergone substantive sentence of 9 years.
87.
More than 9 years.
More than 9 years.
Out of 10 years of sentence imposed by the Lennon trial court. अच्छा से IN number टा दे ले that is IN number so and so लिखी देवे list this matter Mr. से जो जदि 10 वर्ष 9 वर्ष से सुप्रीम कोर्ट अनुଯାয়ী पूरा बेल तक हबो ତେଣୁ ଆପଣ ଖାଲି ନେଇ ଆସନ୍ତୁ ସେ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଟା। ଏଟା କୋଉ ଜେଲ ରେ ଅଛି କହି ଦିଅନ୍ତୁ।
କୋରାପୁଟ ଜେଲ ଅଛି।
This matter for orders कर दियंतु है ना, for orders on 25 September 2023. 25 September 2023 custody certificate be produced on the next date. Free copy of the order be handed over to the land council for this date with LDC IM number है ना। ओके 25 तारीख दिन आसीबो गोटे वीक परे आपण खाली कस्टडी सर्टिफिकेट टा प्रोड्यूस करिवे। ଆଉ ସେ ଜେଲ କଥା କୋଉ ଜେଲ ଅଛନ୍ତି ମିଷ୍ଟର ଚାନ୍ଦ ୱିଲ ଓକେ ଓକେ କିଏ
juvenile bail but 9 months in custody on the last occasion your lordship about to pass that order.
All right, we'll see that.
Found that ghost title is somehow wrong, your lordship, because he was not represented being a minor by his father.
Okay, it will come on 18th. 18th it will come. Yes.
Item 84.
18th para so weekly list as yes.
Item 84 matter related to PCI CBI case में लड़।
हाँ
84.
कौन चाहूँगी?
नहीं supplementary.
Supplementary नहीं अपन रहिला जे पे ये इटा होची रिपब्लिक ऑफ इंडिया मिस्टर सार्थक नायक को कोंतु से प्रिपेयर हेबे यदि प्रिपेयर हेबे थरे सुनानी आरंभ हे गेले सेटा हार्ड इन पार्ट हे गेले प्रूफ पड़े आसो आउ यदि से रेडी जीवे कोन मोर किछ आपत्ति नहीं। यस ऑल द मैटर
Should I begin?
एटा कौन एटा?
Is an appeal against conviction.
नहीं ये पूरा टाइम हो एटा आरंभ जमा ही नथला
ना एटा फिक्स हेतला आजी किंतु ए जो बेंच जो डिवीजन बेंच सकाळे और सिंगल बेंच उपरोळी हेला दीटा
आर सप्ताह रे 21 तारीख रखिले से दिन भी से रविवार अछि से केस
28 छुट्टी
28 छुट्टी नहीं 5 तारीख रहिबो।
रहो 5 तारीख
5th रख दियन जेटा 5/10/2023 एटा हरिदी काउंसिल
CBI.
मिस्टर नायक
May I please your lordship?
this matter will come on 5th October 2023. Today there
Yes,
is
sir.
no time because election petition hearing is to start. Yes.
Yes, your lordship.
Mr. Naikar his name should be reflected in the first decisions in place of Mr. S.K. Padi and G. Mishra. Okay.
God bless you.
लॉर्डशिप एटा रेप केस टा बेसी समय नब नहीं
कौन हॉस्टाइल ही जाइजंदी
evidence has not been corroborated.
No, is it correct?
Evidence has not been corroborated.
No, is it correct that the decoy hostile magisterial hostile?
Minor.
हाँ अकोजन दी magisterial witness भी hostile ही जी
Minor. Magistrate witness your lordship become hostile your lordship.
और बाकी recovery area प्रमाण ये
Recovery has not been. Recovery has been made from the court of the bed court of the accused. It has not been recovered from the possession of the accused.
अपन नहीं रखी थी अपन हाथ तो ये थी बोला
It is only my lord.
आपण को बेडरूम रे आपण को तकिया तले टंका बाहरला आपण को हाथर जो पानी जोटा सोडियम कार्बोनेट सॉल्यूशन वाश रे पिंक कलर चेंज हला आउ बाहर लानी को
My lord, there is no evidence corroborating evidence that the amount somebody says that the amount was kept in the bed, somebody says that the amount was handed over to it. Merely it is
this just think over it आपण को बेडरूम it's not a public place आपण को बेडरूम रे तकिया तले टेंटेड मनी बा ब्राइब मनी बाहरुची हैला आपण को हाथरू हैंड वाश सोडियम कार्बोनेट सॉल्यूशन नेला परे पिंक कलर को चेंज कराउची जोटा की ट्रेसेस ऑफ सोडियम कार्बोनेट solution asuchi chemical examination. I put to you that what is your explanation?
My explanation was that it is also that the money has been intentionally thrust upon. It is the evidence.
Apan bedroom bhitere?
My lord.
Se bedroom bhitru kain jayite?
So it was a plan, but there is no occasion of demanding the money, and there is a plan, and that was been hatched out, and it has been put specifically said. They have specifically said, their witness specifically said, से मना कला तापर हेतु विजिलेंस ऑफिस कहला पर से रखी गण. This is what the evidence is. I've got a written note of.
We'll examine it, but prima facie जदि बेडरूम रे आपनकर पसिले सी एवं पसिकिनी जने थ्रस्ट करियो चाहुचंदी आपनकर हाथ रे आपन तो छिंचाड़ी दबा कथा फोपाड़ी दबा कथा से टंका तळे पड़िबो नचेत बेड ऊपर पड़िबो सी एते साइज हिसाब रे केमती जाई तकिया तळे रहिबो.
That is what the evidence is, your lordship. Evidence is that ସେମାନେ କହିଛନ୍ତି ତାକୁ witness କହିଛନ୍ତି ସେ ମନା କଲା ଠୁ ଇଏ ଆସିକିରି ଜବରଦସ୍ତ କହିଲେ ତୁ ଏଟା ଗଣ ତାପରେ ଇଏ ଏଠୁ କଣ କଲା ଗଣଲା ତାପରେ it was found then your lordship his turn.
Okay, today there is no time, so we'll hear it. You have prepared your note of submission.
My note of submission,
and you have given it to Mr. Das.
Today I will give you.
Okay, সেটা কোন এটা written note of submission?
The written note of judgment.
So file it for the court. The learned counsel for the learned counsel for the appellant and learned Mr. Simon Das, learned senior standing counsel for the vigilance department. The learned counsel for the appellant files the written note of submission along with memo of citation. Giving copy to the learned senior standing counsel. This matter in the সেই ডেটে রখি দিন সেই 5 তারিখରେ ହିଁ ରଖି ଦିଅନ୍ତୁ ହେଲା ଯୋଉଟା ରହିଗଲେ ଗୋଟେ ଡେଟରେ ନେଇ ହବ.
My time file
5th October 2023 ହେଲା.
My letter ଏଇଟା କୋର୍ଟ ଫାଇଲ କରି
ଏଇଟା ଫାଇଲ କର ମୁଁ ଲେଖି ସାରିଲିଣି ଆପଣ ଫାଇଲ କଲେ ବୋଲି. You put the seal of today, okay, and seal ରଖିକି ଇଏ କରି ରଖନ୍ତୁ. ଯୋଉଟା ସଜାଡ ସେ ଇଏ ପାଇଁ ହଁ ନାଇଁ ମୁଁ ଉଠି ଯାଉଛି ତମେ ସଜଡା ସଜଡି କର. ବାବୁ ମୁଁ ଡାକିଦିଏ.
नियम करी पहुंची आते सत कैदी चौकैदी कैदी नहीं सर मते स्वाइन.
Please take this. पानी दीजिए. Okay. Ask without how do you prove it? Okay. So paragraph 10 1 change, all right. 2 ରୁ ଆରମ୍ଭ. ହଁ.
Mirror before the starts cross examination.
Please use the mic properly.
Kindly look to the last page. The questions put in the paragraph 97 to 100 এটা 101 হবে।
ଅବିକା correction କରନି ସେଟା already ହେଇଯାଇଥିବ। ଆଉ ଗୋଟେ paragraph କରିକି ସେଟା copy କରିଦବ। ଆଚ୍ଛା ସେ ଆଜିର ସରିଯାଉ
ଆଜ୍ଞା
ସରିଗଲା ପରେ 101 ରୁ ଏକାଥରେ
ରେଟ୍ 101
ଆଜିର ଯୋଉ
ସେଟା ରହିବ ନା previous date ର
ସେଟା ନାଇଁ ବର୍ତ୍ତମାନ ତ ମୁଁ correction କରିପାରିବିନି କାରଣ I have already put the signature and you have already
order କରିକି ତା ଦେହରେ that is to be read as 100 is to be read as 100 ଗୋଟେ judicial order କରିଦେଲେ ହେଇଯିବ the typographical 100 be read as 101
ଆଚ୍ଛା ହଉ ଇଏ ଆଜିର order ରେ ଉପରେ ସେଠୁ ଇଏ କଲା ପରେ ସେଠି ଲେଖିଦେବେ that Mr. Vidyadhar Mishra, and senior advocate, appearing for the respondent, submitted that when the evidence of the respondent Muhammad Mukim was recorded on on 12/9/2023, he objected to the questions put by the learned counsel for the election petitioner in paragraph number 97 to 100 on the ground that same are beyond same way are like on the beyond the pleadings and amounts to fishing and roving inquiry. So this court recorded the same at the end of the deposition on that day, but inadvertently in place of 101, 100 has been mentioned. Stop. Land counsel for the election petitioner has no objection if the later 100 at the mentioned in the last paragraph within bracket is read as 101 in view of submission made by the land counsel for the respective party. The 101 be read as 100 be read as 101.
evidence
ये जो sequence maintain करते हैं से on जाए
sequence
नले argument बड़ा असुविधा
हां नले फिर खोजिया पड़ियो
କୋଉ ଯାଏଁ ଆସିଥିଲା ପ୍ରପର୍ଟି ଉପରେ ଚାଲିଥିଲା
ଆମେ ସେଇ ପ୍ରପର୍ଟି ମୌଜା ରୁଦ୍ରପୁର ପ୍ରପର୍ଟି ଟା ଚାଲିଥିଲା
पेज नंबर कहतु मुझे भी सेठी तांको मिस्टर मोकिम को मध्य से पेज दियंतु कमर्शियल बिल्डिंग चलथिला बोते मेट्रो रिवर व्यू एगुडा को चलथिला ना
सेटा चलथिला पेज 18 रो जो मौजा रुद्रपुर
सिटी शेल्टर एटा भी चल जाइतला
से सरी जाइछ मौजा रुद्रपुर
ओके
पेज 18 18
हां 18 रो कोटा
मौजा रुद्रपुर चलथिला
हां
सेई थरे मुट खाली टिके
ओके
मुक्तिम बाबू ଆପଣ ଗତ ଥର କହିଛନ୍ତି ये जो मौजा रुद्रपुर रो खाता नंबर 345 प्लॉट नंबर 414 रे आपण को गोटे फ्लैट नंबर A108 फर्स्ट फ्लोर रे अलॉट हैला एवं से कथा भी आपण मानिचंती आपण को एविडेंस एफिडेविट पेज 19 रो देखो
ये बार पर एटा 119 ना
पेज 119 मु बाहर करी दे
हां ठीक है आप
खास सपारा रे
Mr. Mukim Kudala, after completion of the project, namely Metro Satellite City.
Last line, I have kept one flat, that is flat number A108.
First floor for me.
ए फ्लैट टा आपण किणी नाहंती आपण को अलॉट हेची एवं आपण रखिचंती आपण से फ्लैट टा को
Yes, Mr. Mukim, upon लिखिचंती, I kept one flat. That is flat number A108, first floor for me. आपण ए फ्लैट टाकू से प्रश्न होची जे आपण किणीचंती बेली उल्लेख करनांती
किणी नाहंती
हां किणी नाहंती
he has not purchased this
हां
flat
you have not purchased
ये एफिडेविट है
हां ये एफिडेविट है
एटा देखो मु एफिडेविट
आगे से पचारचंती आपण को
ना से चेक करिया को कहबे आगे एटा को आपण कहि सारन
आगे से एया लिखिचंती बेली आपण पचारजन तापर से नेक्स्ट क्वेश्चन पचारिबे से आपण लिखिचंती आपणकर एविडेंस एफिडेविट रे जे आपण गोटे फ्लैट आपण निज पई रखिले
एवं गत थर भी if you my lord looks to his cross examination page 79 he has stated this particular property was developed developed by the company and one particular flat in the first floor that is flat number A108 was allotted in my favor in Metro Satellite City by the company and accordingly I have reflected
हाँ नहीं परचेज कथा तो सेतबेले भी कहि नथिले
नहीं सही पई पर पचार you have not purchased this property
it's a fact it's a fact that I have mentioned in my evidence on affidavit in paragraph number 28 bracket page 119 that after completion of the project, namely inverted comma bhitare single inverted comma Metro Satellite City single inverted comma bhitare comma over the purchased land at Mauja Rudrapur comma I as well as Piyush Dhari Mahanti PEEYUSH धारी टिके छाड़ी किनी डीटा कैपिटल हबो महांती MOHA MO sold out the flats
my lord मने पड़ला
टिके आगे लिखि अपन जहा लिखछन मु डाकी दोजी माने एग्जैक्टली सेया ताकू ये करे दोजी flats oblique units to our customers whereas I kept one flat that is I flat number that is flat number FL80 flat number 1A108 comma दियंतु first floor 1 ST 1 कर दियंतु ST हाँ first floor करंतु for me. Stop.
I have not purchased the said flat. More specific
हाँ
ଅଛି
तापर तापर next question होची आपण एई जो
ये बुझी पार नांती कोन my lord. This land we gave to company for development in a sharing basis. The company को मु land owner हिसाब रे Delhi for development of the projects. से मते 10टा फ्लैट की 15टा फ्लैट की 20टा फ्लैट अलॉट करथि. Out of which मु कंपनी को देथि से बाकी फ्लैट सेल कर दियंतु गोटे फ्लैट बनारे अलॉट करले in exchange of our contract date. No, it purchase the question उठु नहीं.
ठीक है सी यही से पचाउछन सी यही पचाउछन जे ये फ्लैट टाको आपण किणी नाहंती सी यही पचाउछन आपण जोटा कहउछन से यही कहउछन जे आपण ए जो पर्टिकुलर फ्लैट टाको किणी नाहंती बेली
Yes, the cost of my land.
Okay, I have not purchased flat number A108 in the first floor of Metro Satellite City. Inverted single inverted comma bhitar rakhun. But I got the flat in lieu of LIEU, in lieu of
Development agreement.
My land given to the company for development. Hala? Okay. Yes. Next question, please.
For development on sharing basis.
For development on sharing basis. Yes. Achha, on sharing basis. All right.
ଦେଖିଲେ ଆପଣ ସେ ଆଜ୍ଞା affidavit in form 26
हाँ
page 18
1818 हाँ
ଆପଣ ଆପଣଙ୍କ form 26 affidavit ରେ ଲେଖିଲେ date of purchase in case of self acquired property 31/7/2017 ରେ property କିଣିଛନ୍ତି ଏବଂ cost of property ଲେଖିଲେ 30,69,768 ଟଙ୍କାରେ ଆପଣ କିଣିଛନ୍ତି ବୋଲି ଆପଣଙ୍କ evidence affidavit ରେ ଲେଖିଛନ୍ତି and you have made a false declaration
This is a correct
that you
declaration.
have purchased this property.
This is a correct declaration because ଯେତେବେଳେ land ଟା ଆମେ develop କରିବା ପାଇଁ ଦେଇଛୁ in lieu of that land ये
ମୁଁ ଆଜ୍ଞା ସେ କଥା ଆପଣ କଣ ଇଏ
my lord
my question is specific.
my answer also specific.
No, ठीक है Mr. Mukim गोटे heading रहुची column रो heading जे date of purchase in case of self acquired property से जो relevant ये जो particular property रुद्रपुर टा सेटा होची 2 नंबर कॉलम 2 नंबर रे अछि से 2 नंबर हेडिंग रे आपण एठी लेखिले जे डेट ऑफ परचेज से प्रॉपर्टी रो लेखिले 31/7/2017 एवं तापर कॉलम रे आसुची कॉस्ट ऑफ प्रॉपर्टी इन केस ऑफ परचेज एट द टाइम ऑफ परचेज ता धीरे लेखिले 30,69,768 तो एया उल्लेख करचंती तांकर प्रश्न होची जदि ए प्रॉपर्टी टा आपण कहउचंती आपण पाइले आपणकर जमीर जो देइथिले ता बदल रे कंपनी आपण को ए फ्लैट टी ए कला ताले एठी प्रश्न कोट उठुची ताकू केबे किनिले एवं ताकू 30,69,000 टका किनिले बेली जो उल्लेख करचंती एटा फॉल्स डिक्लेरेशन बेली करचंती बेली आपण एफिडेविट रे कहउचंती कोन उत्तर हबो कोन
My lord ଆମେ କଣ୍ଟ୍ରାକ୍ଟ କରୁ कंपनी संगे लैंड डेवलपमेंट ଏଠି मेंशन करा हितला in exchange of that land हमको 6टा फ्लैट ए वैल्यूएशन दिया जीवो जेते ଆମେ 5टा फ्लैट रिलीज करलु तो दिस फ्लैट जेते ଆମେ रिटर्न करलु ଗୋଟେ कंपनी हमको एक्सचेंज डॉक्यूमेंट्स जोटा करला हम सपक्ष रे जेते मेंशन हला फ्लैट नंबर सो एंड सो sold to Mohammed Mukim in exchange of this land exchange hala and the cost is 30 lakhs to 40 lakhs jabi mention nei
तो एटा पई गोटे पर्टिकुलर डॉक्यूमेंट मध्ये अछि जोटा को
yes ma'am
अच्छा
possession letter गोटे डॉक्यूमेंट्स तैयारी हुए डिक्लेरेशंस दा हुए बिल्डर दिए इन फेवर ऑफ द लैंड ओनर तापर रजिस्ट्रेशन हुए
से टाइप से डॉक्यूमेंट किछि आपण देई ना दिएटी
से डॉक्यूमेंट दबारे
ऑल राइट ठीक है ऑल राइट लिखुन इट इज नॉट ए फैक्ट आगे सजेशन दियो इट इज नॉट ए फैक्ट दैट even though the property that is flat number ସେଇଠୁ ନେଇ ଯାଆନ୍ତୁ was allotted to me by the company in lieu of my land given to the company for development on sharing basis, I have made false declaration in my affidavit in Form 26,
Exhibit 43.
bracket Exhibit 43, that this property was purchased and the date of purchase was 31/7/2017, and that the cost of the property, bracket in case of purchase at the time of purchase, bracket ends, comma, the cost of the property to be, comma ta kaट दिया, to be Rs 30, 69, 30, 69, 768, stop, bracket ଲେଖନ୍ତୁ the witness volunteers ତଳକୁ ନେଇ ଆସନ୍ତୁ ସେଟାକୁ टी टाउ कैपिटल करंट a contract was executed by me with the company. Which company?
Metro Builders Odisha.
Say Metro Builders, namely Metro Builders
within bracket Odisha.
Bracket Odisha. Odisha to na Orissa?
Odisha.
Orissa Private Limited. By you only or along with you somebody else was there?
Me and Piyush Mahan.
Acha, by me and by me and Piyush Mahan. This is ऊपर से Piyush Mahan का बनान टा ठीक से लिखूं ये जो आसिकिन हाँ से नहीं Piyush धारी Mahan that नहीं that टी टा छोटा करूँ तो that in lieu of the land, comma, which we provided, comma, the company has to give us 6 flats.
Sir, मैं एक example देनी छोटा flat लो.
Oh, अरे मुगली इतने अपन पहला मुगली बोले छोटा flat.
नहीं ଗୋଟେ ଖାଲି କହିଲି for exact ତାର exact calculation
ହେଲା दी एथी कितना गोटी flat तो अच्छा the company has given a contract was executed by me so and so on which we provided. The company has given us flat number
given me
flat number A108 in the first floor of Metro Satellite City, and a document was executed by the company in my favor.
Yes.
In my favor. In that respect, in which the cost of the flat
company has reflected the cost of
in which the company has reflected the cost of the said flat to be Rs 30
676976
and the document was এই যে 31/7/2017 তাহলে কোন সেই দিন এক্সিকিউট হলা and that particular document was executed on 31/7/2017 and accordingly I have reflected in my evidence affidavit. In my in my affidavit in Form 26. In the columns inverted comma vichar lakhantu, date of purchase in case of self-acquired property, self-dion acquired a property inverted comma says, and I would arambo karantu inverted comma vitare cost of property bracket vitare in case of purchase at the time of purchase bracket says inverted comma ends and according out to back kari jantu and accordingly I have reflected the date the date of purchase and value
Cost of the property.
and cost of the property in my affidavit in Form exhibit as a tip.
7B my lord.
Acha, in column say column taku dekhi diyantu
7B Roman 4.
ସେଠି ଆଉଠି ତଳକୁ ପଳେଇ ଆସନ୍ତୁ ଗୋଟେ କଲମ ଲେଖା ହେଇଛି in column 7 କରିଦିଅନ୍ତୁ column in column number 7 bracket ରେ B ତ B for Bombay bracket Roman 4 ହେଲା
serial number 2
serial number 2 ହେଲା that is i.e. date of purchase one so yes.
ये जो डॉक्यूमेंट ता आपन कंपनी अलॉट कला ए डॉक्यूमेंट ता रजिस्टर्ड है ना रजिस्टर्ड है
I can't remember now whether the document executed by the company on date टा कहते हैं
7/7/2017
ହେଲା in respect of जो flat number flat number टा दीजिए
I can put सब paragraph
I cannot remember सब paragraph I cannot remember now whether the document executed by the company on so and so in respect of land first floor whether registered or not whether I gotcha is registered was registered or not stop yes
अच्छा आपनकर तो मन नाही ए डॉक्यूमेंट ता रजिस्टर्ड हबा दरकार ना नाही
question कर दियो Q whether such a document executed by the company on 31/7/2017 was required to be registered or not question mark answer
सर ये my lord माने स्पेसिफिक कहली भी दरकार भी अछि दरकार भी
आपण जहा कहबे प्रश्न पचारला आपण कहबे बाकी दरकार कि नाही से आर्गुमेंट स्टेज रे देखाबो आपण जहा उत्तर देबे मु लिख देबी
दरकार नहीं
according to me comma it is not necessary stop yes
आपण ए जो कंपनी सागरे जाइछि ऑलरेडी डॉक्यूमेंट फाइल में ए जो डॉक्यूमेंट कथा आज कहउचंती आपण जो कंपनी आपण को फ्लैट अलॉट कला सेटा भी जाइछि
जाइछि
हां काली जाइछि
if you change to other question will make a separate paragraph
आरि धीरे
ठीक है
गोटे अलगा सपारा गली
सपारा
आपण ए प्रॉपर्टी किनिले बोली कि एई एग्जिबिट रे किनिचन
को प्रॉपर्टी देले
एई रुद्रपुर मौजा प्रॉपर्टी
हां हां सेटा दियो डॉक्यूमेंट दियो
ई जेड
एटा मार्क ही जाइछि आगु
ऑलरेडी मार्क है मु आनिछि आ गोटे सर्टिफिकेट बिकॉज़ इट वाज नॉट लेजिबल आई
it was marked on their behalf all right yes
I obtained yesterday
नहीं नहीं it's all right yes
it
हां
was not properly legible
हां एटा होसी रुद्रपुर प्रॉपर्टी
सही प्रॉपर्टी
अच्छा हां व्हाट इज योर क्वेश्चन it is marked as exhibit केते कहउछन
EZ
exhibit EZ देखिए हाँ पाइले नहीं आपण रखन छरा you want it to be written once again or all right Mr. Mukim this EZ is the sell deed in respect of that Rudrapur property it is proved on your behalf आपण ही ताको प्रमाण करैथिले all right e exhibit EZ is the sell deed in respect of
पेज 84 जोटा ऊपर मार्क है सेठी अछि डिटेल डिस्क्रिप्शन ऑफ शेड्यूल प्रॉपर्टी
80
से जो सेल डीड रे EZ रे
मार्क ये हला रे in respect of property of Mauja Rudrapur खाता number 345 plot number 414
एरिया भी था
area एकर 3 एकर 13 डेसिमल
3.13
हाँ 3.13 तो एकर 3.13 डेसिमल यस
ताहले आपण गत थरे कहिसंती it is not a fact that under the sale deed sale deed of property Mauja Rudrapur so and so which were purchased by me and one Piyush Dhari man
property
दी जन के नारे सेल डीड माय लॉर्ड जस्ट ता ऊपर पेज रे होची पीयूष धारी नार ता पूर्व पेज ता होची आंक नारे
भेंडी ना अछि पीयूष धारी महांती ता पूर्वरु अछि भेंडी को ना अछि मोहम्मद मुकीम आ एमान होचंती जीपीए होल्डर सब अछि पावर ऑफ अटर्नी हां एटा दी जन के नारे थिला मिस्टर हां ऑलराइट exhibits one so in respect of the which was purchased by me and by से जो ये नया संसद कॉपी करी पेस्ट कर दियो जो पीयूष धारी महांती जॉइंटली हाँ जॉइंटली कर दियो यस
आपण गत थरे मना करिसंती it is not a fact that my lords can see paragraph 101 of each cross examination
ये पड़ा जो डिपोजिशन ओरिजिनल डिपोजिशन रे टिके दियो
डिपोजिशन है ओहो ताजे दबा एक्चुअली
वो पैराग्राफ का कोई दिन देखला पर पास ऑन कर दे
पेज
78 कौन बोल देंगे
लास्ट
page para 101. The sentence
100 what?
It is not a fact that under the sale deed exhibit E.Z. myself and one Piyush Dhari Mahanti purchased the property mentioned under the heading of description of schedule of property.
ସେଇଟା ସିନା ମନା କରିଥିଲେ
ଆଜ୍ଞା
କଣ ଆଉ ତ ଅଛି ଦିଟା ଆପଣ ଦେଖେଇ ପାରିବେ ଆର୍ଗୁମେଣ୍ଟ ବେଳେ
ମୁଁ ନାଇଁ ଦେଖେଇ ପାରିବି. He has falsely stated that I have not, because on oath he stated I have not purchased. On that day he has given a false statement that he has not purchased this property.
କଣ ଆପଣ କହିବାକୁ ଚାହୁଁଛନ୍ତି ସେଦିନ କାହିଁ ଏମିତି କହିଲେ ଆପଣ ଆଜି କହୁଛନ୍ତି ଏଇ ପ୍ରପର୍ଟିଟା ଆପଣ ସେଲ୍ ଡିଡ୍ ରେ ପାଇଥିଲେ ବୋଲି ଆପଣ ଆଉ ପିୟୁଷ ଧାରୀ ମହାନ୍ତି ଜଏଣ୍ଟଲି କିଣିଲେ ସେଦିନ ଏମିତି କାହିଁ କହିଲେ ସେ କହୁଛନ୍ତି ଡେଲିବରେଟଲି ମିଛ କହିଲେ ସେଦିନ କହିଥିଲେ.
Last day ଆମେ discussion କଲୁ regarding this property by law ଯେ ସେ property ମୁଁ ମେଟ୍ରୋ ବିଲ୍ଡର୍ସ ଓଡ଼ିଶା ପ୍ରାଇଭେଟ ଲିମିଟେଡ ପାୱାର ଅଫ୍ ବେସିସ୍ ନେଇଥିଲେ ସେ ଜଣେ ସମ୍ପୁଷ୍ଟିଠୁ ସେ ପାୱାର ଅଫ୍ ହୋଲ୍ଡର ହିସାବରେ ମୁଁ ସେ ପ୍ରପର୍ଟିକୁ ଟ୍ରାନ୍ସଫର କଲି ଇନ୍ ମାଇ ଫେଭର ଆଣ୍ଡ ପିୟୁଷ ମହାନ୍ତି ଜଏଣ୍ଟଲି ଆଣ୍ଡ ଏଗେନ୍ଷ୍ଟ ଦୁଇ ଜଣ ଯାକ କମ୍ପାନୀକୁ ଦେଲୁ ଫର ଡେଭଲପମେଣ୍ଟ ଅଫ ଦି ପ୍ରୋଜେକ୍ଟ.
ସେଇଟା କ୍ଲିୟର ସେଟା
ମୁଁ ମିଛ କଣ କହିଲି
ମାନେ ଆପଣ ସିଏ କହୁଛନ୍ତି ଯୋଉ ଗତ ଥର ଏଇ ଯୋଉ ଷ୍ଟେଟମେଣ୍ଟ
ସେଲ୍ ଡିଡ୍ ଦେଖେଇଲି ଆପଣ କହିଲେ କି ମୁଁ ଏଇଟା କିଣି ନାହିଁ.
କିଣିଛି ବୋଲି କିଣି ନେଇ କେମିତି
ସେଇଟା କହିଲେ ଆପଣ ଗତ ଥର ମନା କରିଥିଲେ
ମୁଁ କହିଥିଲି
ଓ ରେକର୍ଡିଂ ହେଇଛି ଇଟ୍ସ ନଟ୍ ଏ ଫ୍ୟାକ୍ଟ that under this ଆପଣ ସାଇନ୍ କରିଛନ୍ତି read over and explained to me by the in Odia language admitted to him to be correct and then you put the signatures have been put. You cannot deny that you have not stated like that. So you have mentioned setpai se kohuchandi je you have stated falsehood. So you are denying it. We can record it there. It's not a fact like that. It's not a fact that I have told falsehood.
ପାଇଲଟ ଜାଣିପାରିବି କଣ ଲେଖା ହେଇଛି?
Sorry, sure.
ସେଇଠି ଖସେଇ ଦଉନାହାନ୍ତି
ଦେଖିଦିଅନ୍ତୁ ଆପଣ 101 ର ଗୋଟିଏ ସେଣ୍ଟେନ୍ସ ଫାର୍ଷ୍ଟ ସେଣ୍ଟେନ୍ସ ସେତିକି ଦେଖନ୍ତୁ ସେ ସେଇଆ କହୁଛନ୍ତି ଆଜି ଏଇ ଯୋଉ ଷ୍ଟେଟମେଣ୍ଟ ଟା ପୁରା କମ୍ପ୍ଲିଟଲି କଣ୍ଟ୍ରାଡିକ୍ଟରି ହଉଛି ତା ସହିତ. କେବଳ ପ୍ରଥମ ସେଣ୍ଟେନ୍ସ ଟା ଦେଖନ୍ତୁ ଆଉ କିଛି ଦେଖିବା ଦରକାର. ସେଟା କପି କରି ନେଇ ଆସନ୍ତୁ ସେ ଯୋଉ 101 ହଁ ସେଇ ପର୍ଯ୍ୟନ୍ତ ଆଣି ପେଷ୍ଟ କରିଦେଇଥାନ୍ତୁ ସେ ଯାହା କହିଲେ falsehood on लिखिदियନ୍ତୁ डेट ଦେଇଦିଅନ୍ତୁ on 12/9/2023 at paragraph number କରିଦିଅନ୍ତୁ at paragraph number କରିଦିଅନ୍ତୁ paragraph number 101 of my cross examination. So you are denying that you have not told falsehoods. That is mentioned there. It's not a fact that I have told falsehood on so and so before this court. Before this court. मैं 12/9/2023 पर कहूँ. At paragraph number 10 of my cross examination that under so and so myself and so purchased. No. So then she can't believe. Myself and so did not purchase. Myself and so did not purchase. No mona karthile aji koucheni purchase. Did not purchase the property mentioned. Seita ko say okay. It is not a fact that I have told falsehood on 12/9/2023 before this court.
On oath.
On oath kar den. On before this court on oath. At paragraph number 101 of my cross examination that under so and so myself and so did not purchase mentioned in the heading of the it will probably all right. Yes. Next question.
ଆଜ୍ଞା
Original ଟା ଦେଇ ଦିଅନ୍ତୁ।
ପଚାରନ୍ତୁ ନାହିଁ ଆପଣ ସେ ଠିକ ଅଛି କି ନାହିଁ କୋର୍ଟ ଦେଖି ଆପଣ ଜମା ସିଆଡେ ପଚାରନ୍ତୁ ନାହିଁ।
Yes.
କିଛି ଆପଣ ସେଇ ତ ମୁଣ୍ଡ ହଲେଇ ଦେଲେ ସରିଗଲା।
Yes, yes, next.
Yes, my lord. AEZ cell deed ଆପଣ ଅରିଜିନାଲ ଭେଣ୍ଡରଙ୍କର ଅରିଜିନାଲ ଭେଣ୍ଡର ମେଟ୍ରୋ ବିଲ୍ଡର ମ୍ୟାନେଜିଂ ଡାଇରେକ୍ଟର ହିସାବରେ ଆପଣଙ୍କୁ ପାୱାର ଅଫ ଆଟର୍ଣ୍ଣି ଦେଇଥିଲେ। ଟା ପାୱାର ଅଫ ଆଟର୍ଣ୍ଣିଟା ଆପଣଙ୍କୁ ଇଣ୍ଡିଭିଜୁଆଲ କାପାସିଟିରେ ସେ ପାୱାର ଦେଇ ନଥିଲେ।
EY କହୁଛନ୍ତି।
EY ଟା ପାୱାର ଅଫ ଆଟର୍ଣ୍ଣି on the basis of it he has executed EZ.
ପ୍ରଥମ ନାଁଟା ଥିଲା ଲକ୍ଷ୍ମୀଧର ଶାନ୍ତିଲତା ପୃଷ୍ଟି।
ଆଜ୍ଞା they were the original order.
ହଁ ସେ do hereby
ଜଣ।
nominate appoints one so
5 ଜଣ
ହଁ 5 ଜଣ managing director metro builders as the power of attorney. Okay, hereafter called the attorney holder on our behalf. ତେଣୁ attorney general power of attorney ଦିଆଯାଇଥିଲା in favor of so and so. In respect of which one? Man say
this Rudrapur Mauja property.
अच्छा
अच्छी शेड्यूल आगे से पावर ऑफ
शेड्यूल अच्छे
आगे तळे लास्ट आडू
हाँ रुद्रपुर so and so. Okay, yes, Mr. Mukim एटा 5 जण जाक आपनकु जनरल पावर ऑफ अटॉर्नी देइथिले right? Okay, it's a fact that Santilata Prusti and 4 others
सेपरेट सफारा कर दियो।
अच्छा सफारा कर दियो। हाँ it's a fact
एटा आगे अलगा पैराग्राफ हो।
अच्छा पैराग्राफ कर दियो। हो पैराग्राफ नंबर रिकॉर्ड करूँ 102 जाइछि 103। It is a fact that Santilata Pusti and 4 others executed general power of attorney vide exhibit EY in my favor as the managing director
in favor of the company.
जहाँ लिखा है जी से
लिख दियो in favor of the company as managing director.
in favor of नहीं लिखा है जी जहाँ ना डॉक्यूमेंट
but he is stating something else.
लिखा है जी Mr. You see that page number 2. Please have you got that page number 2? ଦେଇଛନ୍ତି ତ page number 2 को आसिले second sub paragraph and whereas we are unable to look after the scheduled property, do the following acts, deeds, things, hence we execute this general power of attorney in favor of Sri Mohammad Mokim, managing director, Metro Builders so and so. Right? Asiya to likha hoji. Now in my favor as managing director, Metro Builders Orissa Private Limited in respect of property of Mauja Rudrapur
खाता नंबर 345
সেটা লিখি দিଅନ୍ତୁ ଖାତା ନମ୍ବର 345 ପ୍ଲଟ ନମ୍ବର ସେଟା ଲେଖା ହେଇଥିଲା ଉପରେ ମୁଁ 414 ସେଟା କପି କରି ପେଷ୍ଟ କରିଦେବି ହଁ ସେଇଠୁ
हाँ सही
ନାଇଁ ସେଟା ତ ଗଲାଣି
हाँ ये दिया
ହଁ ସେଇ ଯାଏଁ କପି କରିଦେବି ତାହେଲେ ପୁରାଟା କାଟି ଦିଅନ୍ତୁ ହଁ ସେଇଠୁ କାଟିଦେବି ସେଇଠୁ ପେଷ୍ଟ କରିଦିଅନ୍ତୁ ଠିକ ଅଛି ୟେସ୍ ନେକ୍ସଟ
एवं यही पावर ऑफ अटर्नी बल आपण एज ए मैनेजिंग डायरेक्टर ऑफ मेट्रो बिल्डर्स executed the sale deed in favor of you and पीयूष धारी महांती
yes sir
PZ का
EZ
आगे
EZ ଟା ହଉଛି ଗୋଟେ ସେଲ୍ ଡିଡ୍
say on the basis of that power of attorney
ହଁ
as a managing director of metro builders he executed that sale deed in his own favor and favor of पीयूष
Okay.
धारी महांती
हाँ जीपीए होल्डर भी लिखा है मोहम्मद मुकीम और भेंडी ना भी मोहम्मद
नहीं
मुकीम
मोहम्मद मकी मैनेजिंग डायरेक्टर मोर आज्ञा सेठी होची मैनेजिंग डायरेक्टर एज ए मैनेजिंग नॉट
हाँ
दिस
जीपी
पावर ऑफ अटर्नी वाज नॉट इन हिज इंडिविजुअल कैपेसिटी
हाँ दिस जीपीए होल्डर लिखा है मोहम्मद मुकीम मैनेजिंग डायरेक्टर मेट्रो बिल्डर आट पेज नंबर এটা 87 না কোন লেখা কোন 81 বলে
81
हाँ 81 তারপরে পুনি নেম অফ ভেন্ডি লেখা হইছি মোহাম্মদ মুকিম রাইট তাহলে एग्जिबिट इजेड देखौची जे आपण से रुद्रपुर प्रॉपर्टी जो ट्रांजैक्शन ହେଇଛି ତା ଦେହରେ ଆପଣ ଥିଲେ ଆପଣଙ୍କ ନାଁ ଲେଖା ହେଇଛି ଜିପିଏ ହୋଲ୍ଡର ରେ ଆଜ୍ ମ୍ୟାନେଜିଂ ଡାଇରେକ୍ଟର ଏବଂ ଆପଣଙ୍କ ନାଁ ମଧ୍ୟ ଭେଣ୍ଡି ହିସାବରେ ଲେଖା ହେଇଛି ଆପାର୍ଟ ଫ୍ରମ୍ ପିୟୁଷ ବାବୁ कलम नंबर 2 टार एटा होची भेंडर कलम टा नेम्स ऑफ द भेंडर ता देहरे से जो चार जनकर चार जन ना पांच जन आ गोटे ना कोड हला हाँ अच्छी अच्छी पांच हाँ पांच जन अच्छे ठीक है सो पांच जन को ना लिखा हला भेंडर हिसाब रे तापरे किन लिखा हला जीपीए होल्डर आपन को ना रहिला एवं लिखा हला यू आर द मैनेजिंग डायरेक्टर ऑफ मेट्रो बिल्डर्स एवं भेंडी जगह रे आपन को ना रहिला एवं आउ से जो पीयूष धानी को ना व्हाट इज योर क्वेश्चन एटा दैट इज देयर इन द डॉक्यूमेंट इटसेल्फ
डॉक्यूमेंट अच्छा मु तापर सेटा जाऊ नले फिर
अच्छा हाँ
as
एटा
a
देखो
managing director of metro builder he executed that sale deed
in favor of you yourself as well as all right as the managing director of metro builder Orissa Private Limited I executed sale deed by exhibit EZ in my favor as well as in favor of से जो पीयूष धारी महांती सेटा नहीं आसन ठीक है फेवर बनान बोला राइट यस
see page 118 of evidence 118
ओके
आपण देखंतु एटा आपण को एविडेंस एफिडेविट रे लिखिचंती ए पावर ऑफ अटर्नी आपण को फेवर रे हला एवं आपण से प्रॉपर्टी को ट्रांसफर करिचंती इन योर ओन फेवर एंड फेवर ऑफ पीयूष धारी महांती
This is the certified copy of so and so executed by the legal heirs of so and so, okay, in favor of me with respect to the property situated on the same is marked as executable. This is the certified copy of registered sale deed bearing number so and so, executed by so and so. To me, being the power of attorney in favor of me, and one power. Yes. Put the question once again.
You have stated
in the evidence
in your
affidavit.
evidence affidavit,
Page
that
118.
page 118, so also in his examination at chief at page 12. Let us have page 12
Evidence affidavit ro page 12 को दबो.
हाँ नहीं ये जो ताकर जो चीफ से देले डॉक्यूमेंट जो एग्जिबिट कले तार पेज 12 प्लस
अच्छा डॉक्यूमेंट जो देले पेज 12. एवरेट के नहीं. पेज 12 रो को लाइन टा कोजंदी. This is the certified copy of registered sale deed bearing number so and so, executed by.
This is also the certified copy of registered power of attorney.
अच्छा. हाँ.
Executed speak over the last 3 lines. Chandra Purusti in favor of me. My question is, this power of attorney was not executed by the original vendor in your favor in your individual capacity.
Individual capacity. It was as the managing director of this one. Okay. It was not given to you in the individual capacity, but as the managing director, right?
It was like in my favor as managing director.
हाँ. So it's a fact, like it's a fact that the registered power of attorney marked as exhibit EY didn't show or reflect on the show not reflect on didn't reflect that the vendors of the property executed such document in my favor in individual capacity, but as the managing director, say Achita, managing director, Metro Swans. Yes.
एवं आपण as a managing director of Metro Builders Odisha Private Limited and power of attorney holder of the original landowners executed the sale deed exhibit EZ. ଆପଣ ଆପଣଙ୍କ ଇଣ୍ଡିଭିଜୁଆଲ କ୍ୟାପାସିଟିରେ ସେଲ୍ ଡିଡ୍ ଏକ୍ଜିକ୍ୟୁଟ କରିନାହାନ୍ତି.
Back it's a fact that the registered power of attorney matter did not reflect that the vendors of the property bracket original
owners of the land.
Original owners of the land. Executed such document in my favor in individual capacity, but as the managing director so and so. Next question टा होची जे सेही कैपेसिटी रही सेटा जो सेल डीड एग्जीक्यूट करचंती
not as an individual.
एरा कोन कोजन सेही कैपेसिटी तो कारण obviously एही तो देखो it's a fact that in the capacity आज Senior the managing director so and so, I executed সেটা কোন সেটা
সেল ডিড এক্সিবিট
হ্যাঁ সেল ডিড ভাইড এক্সিবিট কেতে সেটা ইজেড in favor of me and Piyush Dhariman. Yes.
ତାହେଲେ ଆପଣ ଆପଣଙ୍କ ଏଇ ଯୋଉ ଏଭିଡେନ୍ସ ଏଫିଡେଭିଟ ଲେଖିଲେ କି ଆପଣଙ୍କ ଫେଭରରେ ଅରିଜିନାଲ ଲ୍ୟାଣ୍ଡ ଅର୍ଡର ପାୱାର ଅଫ ଆଟର୍ଣ୍ଣି ଦେଇଥିଲେ ଏବଂ ଆପଣ ନିଜ ନିଜ ପାଇଁ ଏବଂ ପୀୟୁଷ ଧାରୀ ମହାନ୍ତିଙ୍କ ଫେଭରରେ ସେ ସେଲ୍ ଡିଡ୍ ଏକ୍ସିବିଟଟା ମିଛ କଥା ଲେଖିଛନ୍ତି। He has written executed
in me ଲେଖି ଦେଇଛନ୍ତି that should have been the in
as
ସେଟା omit ହେଇଯାଇଛି ସେଟା। ସେ 12 ନମ୍ବର ପେଜ ରେ ଆଉ ସେ ଯୋଉ 118 ପେଜ ରେ 12 ନମ୍ବର ହଉଛି ଆପଣଙ୍କର ଚିଫ ଏକ୍ସାମିନେସନ କଣ୍ଟିନ୍ୟୁ କଲା ଆଉ 118 ପେଜ ଟା ହଉଛି ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ଆଫିଡେଭିଟ ରେ ଆପଣ ଲେଖିଦେଲେ ସେ ଯୋଉ ରେଜିଷ୍ଟର୍ଡ ପାୱାର ଅଫ ଆଟର୍ଣ୍ଣି ଆପଣଙ୍କର ଏକ୍ଜିକ୍ୟୁଟ ହେଇଥିଲା ଇନ୍ ଫେଭର ଅଫ ମି it should have been in favor of me in the capacity or as man ସେଗୁଡାକ omit ହେଇଛି it's a fact it's a fact that I have omitted to mention in my evidence affidavit at page 118 bracket ରେ ପର୍ଯ୍ୟନ୍ତ first sub paragraph
second data goes clearly
acha first and second part the first and second sub paragraph and second sub paragraph as well as in my chief examination in examination in chief bracket like at page 12 that the registered power of attorney by exhibit EY was executed
registered power of exhibit EY and sale deed
and sale deed by exhibit EZ where were executed by me in সেটা হবো in favor of me না উপরটা হবো power of attorney টা in my favor হবো that the registered power of attorney by exhibit EY was executed সেটা লিখুন was executed in my favor ହେଲା
were executed by me in favor of and the sale deed
ठीक है sale deed টা পরে আসে গোটে paragraph it is it's a fact that I have omitted to mention in my affidavit at so and so first and second paragraph টা হচ্ছে আপনাদের সেল ডিড টা না তাহলে সেটু খালি ফার্স্ট করে দেন ফার্স্ট paragraph টা করুন ହେଲା first sub paragraph as well as in my examination in chief paragraph number ରହିଲା page number 12 ରହିଲା that the registered sworn deed by sworn so was executed in my favor omitting দেখুন সেই সেট নাই সেটা কাটি দেন সেটা তলু নিয়ে আসবেন omitting in the capacity of managing director say jota managing director so and so it's a fact that I have omitted to so and so mention in my evidence affidavit around it's a fact that I have omitted to mention in my evidence affidavit at page 118 first sub paragraph as well as in my examination in chief at page 12 that the registered power of attorney via exhibit EY was executed in my favor in the capacity in the meeting in the capacity of so and so, and it's not a fact that I have made false declaration. It's not a fact that I have stated falsehood for them. I have stated falsehood
in my evidence.
in my evidence affidavit,
Exhibit DW.
Exhibit DW, as well as in my examination in chief in that respect. Hala? तापर सेमती सेटा को नहीं आसंदु से जोटा सेल डीड टाको सेटा कॉपी कर नहीं आसंदु पूराटा नहीं आसंदु सेटा सेल डीड खेले हो
सेल डीड एग्जिबिट नंबर बदल
हाँ it's a fact that I have omitted to mention in my evidence affidavit paragraph rela 118 सेटा होची second sub paragraph as well as in my examination in chief सेटा होची 8 page 12 ठीक अछि that the registered power of attorney wants to nice सेटा होची cell deed registered cell deed कौन registered cell deed हला marked as exhibit was executed by me executed by me
managing director Metro Builders.
Executed by in the capacity of. It's not a fact that I have stated falsehood in my evidence affidavit so as well as in examination in chief in that respect. ठीक है yes. आप तो पढ़िए आप तो पढ़िए.
That's fact that I omitted to mention. Verification of the period.
आपण एटा एक्सेप्ट करूचंती जे मु एटा ओमिट कर देइची जो मेंशन करिवा को इन द कैपेसिटी ऑफ मैनेजिंग डायरेक्टर मेट्रो बिल्डर्स रे मु सेटा जनरल पावर ऑफ अटॉर्नी पाइथिली प्लस सेही कैपेसिटी रे मु सेल डीड खाली लिखि देइचंती आपण दीटा जगह रे मी लिखि देइचंती ओमिट कर जाइचंती बोली आपण एक्सेप्ट करूचंती. Yes, Mr. Next question. Sorry, Vani.
And I will go to that next part.
आउ कितना ये रही लगी माने एटा तो हल्ला आपन को
एफिडेविट सॉरी ऊपर अछि
एटा आपन को बर्तन को हेडिंग टारे चलची जे
एटा हमें कॉलम 7 में चली
आउ कितना कॉलम अछि
नहीं आई हैव टू ओनली
आ गोटे लोन ताजरे किछ क्वेश्चन पचरे अछि
सेटारे खाली पूरा रहला पार्ट बी टा
अच्छा
पार्ट बी टा लोन टा
अच्छा
पार्ट बी टा
My objection may be
हाँ मुले I think have you put question से जो या करे से जो फॉर्म
मेरे सेटा आधा रह जाई छी हां सेटा वो कॉलेज के रखी छी रेडी सेटा गोटे दिन साथी
हां कारण सेटा गोटे
2 बीटा जोटा
हां जोटा
आउ दैट एफिडेविट डेटेड 24 एंड
हां से कारण आपण बोधे क्वेश्चन स्टार्ट करथिले से जो ये पूरा नहीं आसिले क्राइम जो सेटा नेकिन चले
up to page 39
जस्ट गोटे टच कर देई कि नहीं सेही पार्ट टा
up to page 40 of your examination chief साथ देई
हां हां
तापर मु क्रिमिनल पार्ट और ये
सेटा तो सरी गला तापर पुणे बैक करिवे से
एफिडेविट रो पार्ट बी टा खाली के पछा देई तापर बैक कर दी
से जो फॉर्म ऊपर जोड़ा था ऑलराइट सो वी विल कीप इट टुमारो
गोटे दिन
काली तो 3टा बेले रखि थांतो आपण कथा हितला आपण काली सर दी थांदे
मोर आगे खाली एटा मु आज भी जदी अधवटा बच्चा
हां
मोर दीटा डेट बिल्कुल बेसी हो खाली आपण ए परा जोटा कर देले ए पय आज गोटे दिन बढ़ी गला मोर ନହେଲେ ସରିଯାଇଥାନ୍ତା ଆପଣ ନିଜେ ମନା
ନାଇଁ ସେ ଯୋଉ ଆପଣଙ୍କର ଯୋଉ ସେ ଫର୍ମ ର ଯୋଉ ଓମିଶନ ଫୋମିଶନ ସେଟା ତ ଗୋଟେ ଦିନ ନବ ବୋଧେ।
ଫର୍ମ ଆଫିଡେଭିଟ ଯୋଉ ଦୁଇ
ହଁ ସେ ଗୋଟେ ଦିନରେ ସରିଯିବ।
ପାର୍ଟଟା ଖାଲି ଗୋଟିଏ ରହିଲା।
2 ଦିନରେ ସରିଦେବେ କହୁଛି।
ଏଇଟା ବି ବେଶୀ ନାହିଁ, ଏଇଟା ବି ସରିଯିବ 10 ସେ
ତ ମିଷ୍ଟର ମୋକିମ କାଲି ତ 3ଟା ବେଳେ କଣ ଅସୁବିଧା ହଉଛି କିଛି ଅଛି? ନାଇଁ ଏଇଟାକୁ ସେ କଣ୍ଟିନ୍ୟୁ କରିବେ ଏଇ ଯୋଉ ଯାହା ଛାଡିଲେ ଏଇ ଗୋଟେ ଜିନିଷ ତାପରେ ଆଉ ଗୋଟେ ଦିନ ରହିବ ସେଇ ଯୋଉ ଆପଣ ତାଙ୍କ କ୍ୱେଶ୍ଚିନ୍ ହବ ସେଇ ଯୋଉ ଆପଣ ଯୋଉଟା ଫର୍ମ ଟା ଯୋଉ ଡିଲିସନ କରିଛନ୍ତି ତାରି ଉପରେ କ୍ୱେଶ୍ଚିନ୍ ହବ ସରିଯିବ ଆଉ। So let us keep it tomorrow at 3 o'clock, okay? All right.
Questions part.
अरे से objection टा सान करो note करिए।
Questions put
हाँ
with respect to paragraph 102 to onwards.
सेटा कॉपी करी आनी पेस्ट कर दियंतु। लेक्चर ने लेखा ही रहने सर देखिए देबो अपन।
आज्ञा।
Question put from paragraph number 102 and dita paragraph है जी। अच्छा, we are objected to by so and so, okay.
Bye.